The Senate will come to order. Members, there's a privileged report at the desk. The Secretary will read the report.
Senator Dietzig from the Subcommittee on Conference Committees recommends that the following senators be, and they hereby are appointed as a conference committee on Senate File 1384, Senators Murphy, Abler, and Bolden. Senator Dietzig moves the foregoing appointments be approved.
On that motion, any discussion? Seeing none, all in favor say aye. All those opposed say no. The motion prevails. Members, we are remaining under the order of business of motions and resolutions. Senator Bolden.
Thank you, Mr. President. Pursuant to Rule 26, I designate the following bills be made special orders for immediate consideration. Members, the list is on your desk.
As Senator Bolden mentioned, remaining under the order of business of motions and resolutions, we revert to the third order of business. Oh, I'm sorry. Nope. Special orders. You have that special orders list on your desk? You don't have one? It's coming right now. Members, just so you know, we're going first to General Orders number 145, which is Senate File 3307. Senator Latz, this is for the miscellaneous oversights, inconsistencies, ambiguities, unintended results, and technical errors correction bill. With that being said, Senator Latz to Senate File 3307.
Mr. President, members, this is the annual technical corrections bill, sometimes called the Revisor's bill. It's a standard end of session cleanup for stuff that's already been passed during this session, and sometimes there are technical oversights, a missed statutory reference or a word that was dropped or a date that wasn't inserted where it should have been. So these are purely technical corrections, and should be nothing controversial in. Everything that's in the bill has gone through a process of getting approvals from the original bill's chief authors, the committee chairs, the principal committee chairs, and both the GOP and DFL authors of this bill in this year. That's me and Senator Limmer. So it should be no surprises. The process here is we're going to pass this off of the Senate floor. It'll go to the House. The House will make any additional final corrections before the end of session with amendments on the House floor, then send it back to us for final approval. So this will get the process rolling so it doesn't get lost in an end of session logjam, to make sure everything that we have passed this year gets done in a proper and technical fashion. That's all I've got. Happy to stand for questions.
Any discussion or questions on Senate File number 3307? Seeing none, the Secretary will give Senate File number 3307 its third reading.
Senate File number 3307, a bill for an act relating to legislative enactments correcting miscellaneous oversights, inconsistencies, ambiguities, unintended results, and technical errors.
Third reading. Any discussion on Senate File 3307? Seeing none, the Secretary will take the roll for final passage of Senate File number 3307. Members, please vote. Senator Bolden, for those voting under Rule 40.7.
Thank you, Mr. President. I report that Senator Mann votes aye.
Senator Mann votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Wickland votes aye.
Senator Wickland votes aye.
And Senator McEwen votes aye.
And Senator McEwen votes aye. Members, remember, we're just voting on the technical bill for the revisor's office. Craig, Jason? Senator Rasmussen, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Duckworth votes aye.
Senator Duckworth votes aye. All senators having voted who desires to vote, the secretary will close the roll. There being 57 ayes and 5 noes, the bill is passed and its title agreed to. Members remaining under the order of business and motions and resolutions, we will revert to the third order of business. Messages from the House. The secretary will read the message.
Mr. President, I have the honor to announce that the House has adopted the recommendation and report of the Conference Committee on House File Number 2 and repassed said bill in accordance with the report of the committee so adopted. House File Number 2, a bill for an act relating to employment, creating a family and medical benefit insurance program. House File Number 2 is herewith transmitted to the Senate. Signed, Patrick D. Murphy, Chief Clerk, House of Representatives.
Senator McQuaid for a motion.
Thank you, Mr. President. I move that the foregoing recommendations and Conference Committee report on House File 2 be now adopted and that the bill be repassed as amended by the Conference Committee.
Members, Senator McQuaid moved that the foregoing recommendation and Conference Committee report on House File 2 be now adopted and that the bill be repassed as amended by the Conference Committee. Senator McQuaid, to that motion, please explain.
Thank you, Mr. President. Members, I am humbled to be carrying House File 2 across the finish line today, paid family medical leave. Being distributed to you now is a Facebook post from 7 years ago, almost to the day, celebrating a medical doctor's completion of her master's degree of public health from Johns Hopkins School of Public Health. That doctor's thesis for that master's degree was titled Paid Parental Leave, Does America Need It? Her work will, and I'm going to quote her mother here, only contribute to a better society. That doctor and master of public health is our colleague and my friend, the good senator from Edina, Senator Dr. Elise Mann. Senator Dr. Mann has done so much work to bring this bill to us today. She has had literally hundreds of meetings, shepherded this bill through 8 committees, She accepted numerous amendments, many from our Republican colleagues, and suggested by business groups. And in those hundreds of meetings, she met with, and I'll quote her here, business owners, large, medium, and small, businesses in the metro area, greater Minnesota, and everywhere in between. She met with cities, counties, school districts, the hospitality industry, educators, resorts, seasonal industries, agriculture, healthcare, and of course the families and everyday Minnesotans, which to her and myself are the most important people because they show up here to tell their stories and they don't come with lobbyists. Senator Mann and her partner in the other body, Representative Ruth Richardson, did the exact kind of work that takes our Minnesota values, turns it into a great bill, which will become transformative policy for Minnesotans and their families. So again, Mr. President, I'm humbled to be carrying this across the finish line today. As I was preparing to present this bill, I was reflecting on this session because we're only 5 days away from the end. And while this body is not necessarily representative of Minnesota, we do represent all of Minnesota. And we need look no further than the 67 members of this chamber to understand the varying reasons why Minnesotans need paid family medical leave. Just this year, the good senator from Brooklyn Park had a baby. The good senator from Olivia was on active duty orders. The good senator from Minneapolis had a cancer diagnosis. The good senator from Alexandria was in a snowmobile accident. I myself had a baby in the pediatric ICU. And the good senator from Edina was diagnosed with cholecystitis, which is an inflammation of the gallbladder, and she needed emergency surgery to remove it right away. And just for everyone to know, she's recovering without complications. It's just painful, and she's going to be out for about 2 weeks. None of us were out for 20 or even 12 weeks. We were mostly not overlapping. We, the members of this chamber, the 67 of us who represent all Minnesotans, exemplified perfectly the reasons that Minnesotans will take leave. Through committee stops and also on the floor, it has been infuriating that the Minnesotans who need access to paid leave, which is 76%, 76% of Minnesotans, Mr. President, have been left out of the conversation. And while I know this bill incredibly well, Senator Dr. Mann, chief author, master of public health, has described this bill best, so I'm going to quote her again here. With paid family medical leave, we see decreased maternal morbidity and mortality rates at a time when America's rate of maternal morbidity and mortality are at an unacceptable high. Compared to the rest of the world, we stand out amongst developed nations in how horribly our moms and babies are doing. We see increased rates of breastfeeding with paid family medical leave, which we know is good for moms and people who gave birth and their babies. We see an increase in parental mental well-being. We see better health outcomes for children with decreased rates of ear infection, gastrointestinal infections, pneumonia, decreased number of clinic visits, and decreased rates of hospitalizations for these babies. We see increased financial stability for families after a life-changing event, which leads to more people returning to the workforce instead of leaving it altogether. This program leads to increased employee retention, and it has bolstered the workforce in states that have implemented this program. You will hear today that this bill might impact our child care shortage and our long-term care shortage, but when families are more financially stable, we see a decrease on the reliance of government services. Data shows that 21% of people that take unpaid leave have to turn to the government for assistance. Paid leave is a gender justice issue. We know that when everyone has access to leave, gender discrimination in the workplace decreases. And this is a racial justice issue, Mr. President, because too often our communities of color are left out of such programs, including people who live with disabilities. Our bill is written in a way where no one is left out. Obviously, paid family medical leave is an economic issue, but also it's a small business issue because this will give small businesses the opportunity to compete with larger businesses for talent. They can now offer a program that we know increases workforce participation. Paid leave is linked to increased business productivity, higher employee morale, better recruitment and retention of skilled workers, and the reduction of costs related to employee turnover. End quote. That was all Senator Mann before that. So top line from the conference committee report, members, we held strong on Senate positions, including the Senate position on the maximum length of leave, the direct care provider account, the premium cap, and serious health condition is a 7-day qualifying event. Big change to note, the implementation or start date of the program is January 1, 2026. Minnesotans should be able to work and care for themselves and their families, Mr. President. And this program is built on a foundation that all people are worthy, that all of our life experiences and life trajectories are equally important. And I'm going to end by doing something that I never thought I would do on the floor of this chamber and quote the senator from Mazeppa. Yesterday, I think it was yesterday, yes, it was yesterday, he said, we need to encourage families to stay together, to bond with their kids, to develop their families, to strengthen families, to keep both parents and have cohesive families, and not take kids away from their families at birth. Well, to my good friend, the senator from Mazeppa, and all members, this is our bill to do that. So I encourage all members to vote green and adopt this conference committee report. Thank you, Mr. President.
Senator Draheim, we are on House File 2, adopting the conference committee report. Senator Draheim.
Thank you, Mr. President, and thank you, Senator McQuaid, for the opening remarks. Members, I would move that I recommend that we send this back to the conference committee on House File number 2, and it be rejected, and that the bill be re-referred to the conference committee as formally constituted for further consideration. And members, primary reason for that for me is the local impact. We have requested a local impact study. That local impact study is not back yet. This does not go into effect till 2026. We have time. We have next year to finish the work that was started years ago by many members in this body. Senator Mann this year, Senator McQuaid, Senator Coleman last year, and others. So members, please support the motion to send it back to the conference committee. Thank you.
Members, Senator Draheim moved that the recommendations and conference committee report on House File 2 be rejected and that the bill be re-referred to the conference committee as formally constituted for further consideration. To that motion, Senator Pratt.
Thank you, Mr. President and members. Members, I stand in support of Senator Draheim's motion. Back in January, even before this bill had just started its pass through the committees, we were hearing from school districts, cities and counties, hospitals, about the impact that this bill would have. Not what impact having some sort of option for paid family and medical leave would be, but the impact that it would have on them as an unfunded mandate. They're concerned that they would have to pass those costs on to their property taxpayers. Many of them saying they already offered a plan that their employees seemed to like, even though it wasn't exactly what the state was mandating. And at that time in finance, I asked Chair Marty if we would hold off on hearing paid family medical leave until we had that local impact note back. And he said that sounded reasonable. So he and I together drafted a request for a local impact note. It went out that very day. And the Legislative Budget Office is telling us that that's going to be ready here just after the end of session. It takes a while to get these local impact notes done. Now, Senate Republicans have also offered a plan that would be less prescriptive on local taxpayers, less prescriptive on our local employers, and it was rejected. So now we're waiting for the local impact note, Mr. President, a local impact note that was described as being reasonable that we hold off on this bill until we get that back. It went through finance without a local impact note. It passed off this floor without a local impact note. It's now back from conference committee without a local impact note. A local impact note that, again, Mr. President, was described as a reasonable request. Not a delay tactic, a reasonable request. Because as we've talked on all of these omnibus bills,
And one that sticks out in my mind is the education bill, where we are putting a lot of money into local school districts. But members, we have all these mandates and fees that will cause them to have to make budget cuts, and this is one of them. Many of our collective bargaining agreements already have some version of a leave policy. Those are going to be wiped out. Now it's going to be an additional payroll tax. And not only a payroll tax on the small businesses and the public entities, but a payroll tax on the working men and women of Minnesota. More money out of their paycheck at a point in time when they need that additional money for groceries and gas and health insurance. Mr. President, this needs to go back, in part because we don't know the full effect that this bill will have. We've said it's reasonable. We've said that it should be something that the legislature knows. I've speculated that maybe we don't want to know. Maybe the majority doesn't want to know because they're afraid of what that number will be. We had a cursory look just at part of what the local impact would be, and it's over $200 million. Over $200 million in the first year. $200 million coming out of Minnesota working family paychecks. $200 million being paid by your local school district, your city, and your county. $200 million that may already have, for people who may already have a benefit that they like, but it doesn't match what the state says. In part because we've not looked at any other options than an option that hires over 400 state employees in the Department of Employment and Economic Development. Think about that, members. Over 400 employees. Over 400 employees that will now also be contributing into this program when they already have a program. This bill was premature when it left the Senate floor. It's premature coming back from conference committee. We owe it to the people of Minnesota to be transparent. We owe it to the people of Minnesota to be truthful on what it's going to cost. We owe it to the working men and women of Minnesota to know how this is going to impact them. Mr. President, would Senator May Quaid yield for a question?
Senator May Quaid, will you yield? She will yield. Senator Pratt.
Thank you. Senator May Quaid, can you talk about some of the key changes that came through the bill out of conference committee?
Senator May Quaid, to the question.
Thank you, Mr. President. And Senator Pratt, I'll just restate my opening statement. Top line reports from the conference committee. We held strong on Senate position, including maximum lengths of benefit, direct care provider account, the premium cap, the serious health condition as a qualifying event. Big change was the implementation date of Jan 1, 2026. We took the definition on family from the House. We tightened up seasonal worker, and I think those are big top lines. I would be happy to answer more questions, Mr. President.
Senator Pratt.
Thank you, Mr. President. Mr. President, when the bill left the Senate, and we had quite a bit of work on this, and I appreciated Senator Mann's partnership in getting this and working with the Department of Employment and Economic Development, Mr. President, we had that in the actuarial study that if the program was not actuarially sound, then the commissioner would have to come back to the legislature with proposed fixes. He would have to make recommendations. Because it's not just about the premium, it's about the entire program. Senator McQuaid, would Senator McQuaid yield for a question?
Senator McQuaid, will you yield? She will yield, Senator Pratt.
Thank you, Mr. President. Senator McQuaid, I worked with Senator Mann on that language, the agency. Can you tell me what happened to that part where it said the commissioner would have to come back with recommendations?
Senator McQuaid to the question.
Thank you, Mr. President. So, members, just as a reminder, the actuarial study is going to come back from a qualified independent actuarial consultant to conduct an actuarial study of the family and medical leave program, all the components of it. I won't read all of the components. Mr. President, Senator Pratt will be happy to know that the department went through and corrected some of the language. There were some typos and some misreferenced pieces, and so we tightened that up. But for the actuarial study, the U.S. Department of Labor did a microsimulation model that details census data for the state, leave data by the Department of Labor, and then models in the attributes of a program. And they run a regression model to estimate the number of people taking leave and then the cost. So other states have used this model, and that's how we have come to the assumptions in this bill. One of the great things, or I'm sure it's a great thing about actuarial scientists, is that they tend to be really cautious when they do their estimations. So one of the things that we know is that people who take leave sometimes will have accompanying benefits from their company, whether it's paid time off or accrued vacation. And so even in the estimations that were done in our model, it didn't account for some of the places where people might have leave that they will take combined with this. And so the actuarial study is going to study what the premium rate should be in all of the components, and then the commissioner can adjust the premium rate to make the program actuarially sound with a premium cap of 1.2%. The wonderful thing that we've seen in other states that haven't undershot this is that premium rates are coming down and they're able to increase benefits because this program is so beneficial to their members. One of the things that I think is really important to know is that Senator Pratt, Mr. President, mentioned a few times that Republicans offered some plans. They offered plans that are proven failures, which is why we're not doing that bill. We're doing the bill that works. We're doing the bill that helps people care for their families, care for themselves, and put money back in their pockets while they're doing it. So one of the things we did do, though, is we removed the prohibition on private plans being able to offer this, and so part of Senator Coleman's bill is reflected in this bill, and if private plans want to compete, they absolutely can. When we have done what Senator Pratt would like to do, 99.7% of employers did not sign up. That program does not work. Every Minnesotan needs paid time to care for themselves or a loved one. And so we know that this plan is the proven plan. And if we want to talk about the local impact, I would love to do that. The local impact to paid family medical leave is a 32% reduction in the respiratory and intestinal infections for babies. This could cost us anywhere from $4 billion annually. California has seen a 6.6% drop in preterm births. This is about $20 million annually, and this would be more than 500 babies in the state of Minnesota. Paid leave programs help seniors age in place. California's program has shown an 11% drop in nursing home utilization. This would save Minnesota around $60 million. Unpaid help allows seniors to age in place in Minnesota, and that's about $7.9 billion a year. We know that this helps people not rely on government assistance. There are cost savings to businesses because they don't have to retrain, they retain their employees. And so the local impact of this, Mr. President, is significant, and it's amazing. And I am so, so excited that we have this bill before us, which is ready. It has been researched, and 11 other states have passed this already, which means we have had the opportunity to learn from them and do it the best, because Minnesota is the best. So, members, we don't need to send this back. It's ready. It's not rushed. We got 5 days left in session. This bill's been around for 11 years. I'm ready to go, Mr. President. Thank you.
Senator Pratt.
Thank you, Mr. President. Well, Mr. President, I would respectfully disagree with the senator from Apple Valley. Actuarial studies are not overly conservative. They're based on facts. They're based on past observed occurrences. I spent a lot of my career managing risk in the financial services. We were able to statistically model behavior that was very, very close to the actual outcome. It's not a guess. And I appreciate that Senator Mann took my language to tighten up who was able to perform these actuarial studies. Because what we saw in another state, Mr. President, was that a firm that was promoting paid family and medical leave run by the state was hired to do the actuarial study. They did not follow the science. They did not follow the data. And so I do appreciate Senator Mann keeping in the language that an actuarial consultant is one who is a fellow of the Society of Actuaries and a member of the American Academy of Actuaries and has experience directly relevant to the analysis required under this paragraph. It's extremely important that we have someone qualified. But, Mr. President, it is short-sighted for us to presume that the only variable that will make this program actuarially sound is the premium. We've seen in other states where the premium can be north of 1.2%. It could be 1.6%. And what are we going to do without the language that left the Senate? Because we've tied the commissioner's hands. All he can do is raise the premium. All he can do is raise the tax on hardworking Minnesotans. And it may not be enough. Because, Mr. President, as I'll speak to later on, if we're to look at the experiences from other states, we are going to be dipping into the reserves of this program. Out of the gate, it's going to be running more in benefits and costs than are being proposed in the bill itself, in the premium that's coming back at the 0.7. And I'll have to go back and look at those charts. I don't have them handy with me. I was expecting to talk to them later, Mr. President. But we may have to exceed a 1.2% cap. And yet here we are implementing a program without any actuarial study, without any qualified analysis other than what the advocates have done, the advocates who have a stake in making sure that this passes the way it passes. I would also like to just say, Mr. President, that I don't believe the Republican plan is based on failed programs from other states. Because what this plan does is it presumes that everybody must have this program. Everybody must contribute, whether you want to or not. Democrats know better what needs to be in your paycheck deductions than you do. We've seen this. We saw it with the forced enrollment into a retirement account. Not that you opted in and you decided that, yes, I want that money extracted from my paycheck. No, you're forced into it and you have to take action to get out of it. We may have teenage workers that don't want to be in this program. They don't have a choice. The Republican plan offered working Minnesotans a choice to decide if they wanted this coverage or not. It was loosely based on a state, Mr. President, that just recently implemented And within just a few months, 149 companies employing 6,100 people, as well as 644 people on their own purchased coverage. The state also put in nearly 9,000 permanent employees into the system. Now, some might say that's not working, that's not enough. I would disagree. It's a brand new program, Mr. President, and we don't know what the timing for enrollment is. Everybody's got a different fiscal year. When I worked in a bank, our fiscal year started on January 1st. When I worked for a retailer, our fiscal year started February 1st because we wanted to count January in our holiday sales. The state fiscal year starts July 1st. The federal fiscal year starts in September. So there's time for this to go on. The program's been up only a few months, and rather than calling it a failure, they're calling it a success. A success that looks very much like what Senator Coleman and I have proposed over the last 2 years. So, Mr. President, I believe that we owe it to Minnesotans to send this back to conference committee. I think we owe it to Minnesotans to make sure that we re-implement the actuarial language that Senator Rasmussen, Senator Mann, and I all worked on. I think it's important we send it back to conference committee to make sure that we have all of the information for Minnesota families. They know exactly what it's going to cost them in additional property tax to cover their schools, to cover their cities, to cover their counties, to cover their hospital workers. Because unlike the promises we've heard, such as if you like your doctor, you can keep your doctor, that have been broken, they didn't even make the promise, if you like your plan, you can keep your plan for paid family and medical leave. They're just taking it away from you. They're just replacing it with what they want. The state legislature has decided for Minnesotans, you don't know enough about what you need, we're going to take care of you. So, Mr. President, we ought to send this back. This is too important. This is a $1.5 billion tax on Minnesotans. This is a $1.5 billion tax on Minnesota workers. And I say that, Mr. President, because even though the language says half the premium will be paid by the employer and half the premium will be paid by the employee, we know that the entire burden of this tax is going to be shouldered by the employee. They're going to get less in wages because the employer is going to have to factor in the cost of this program into the total compensation that an employee gets. It's going to potentially lead to fewer job opportunities because an employer is going to say, boy, it's just too hard to hire people at what I have to now, I'm just going to cut back. And it's going to be hitting Minnesota families who are not only paying for their own coverage, but will be paying for the coverage for public employees as well. And those public employees will see less in their paychecks as a result of this. Mr. President, I'm opposed to the Democrats' plan for paid family medical leave. That's not a secret. I am a proponent of paid and family medical leave, as Senator Coleman has proposed it. But, Mr. President, for the motion to send it back to conference, we should all be opposed to the fact that the actuarial study language was watered down and that we broke a promise in this body to wait until we got the local impact note, a promise to be transparent to the people of Minnesota. So, Mr. President, I ask members to vote yes on the Draheim amendment.
Senator Rasmussen.
Thank you, Mr. President. I also rise in support of Senator Draheim's motion to send this back to the conference committee. I think there is still work to be done to get this right. And I think it's really interesting that in the conference committee report before the body, that the bill does move out the effective date to January 1 of 2026. Mr. President and members, we have time to get this right. In the conference committee report, it asks for an actuarial study to be done by October of this year. Yet, I guess without sending this back to conference committee, that means that this body is flying blind and not knowing the actual numbers behind this bill to make sure that the taxes, the revenue coming in, will match the promises that are being made to Minnesotans in this bill. As has already been stated by Senator Pratt, we also have requested and are still waiting for a local impact note to understand the impact that this is going to have on school districts, city government, county government. We also really don't know the impact that this will have on nursing homes and disability services. This was something that we talked about on the floor when this bill passed off the floor, and we still don't have good answers about how our disability services and nursing homes are going to pay for this increased cost. And another point I want to make was the Senate position actually didn't stand very strong when it came to the maximum premium rate. We, on a voice vote here in the Senate, had a 1% premium cap that was going to go with this bill, even though we've been hearing from proponents that it's going to be a 0.7% payroll tax on Minnesotans, that we were able to have a 1% cap on that tax. Yet when this report comes back, it now has a 1.2% cap. And so, Mr. President, would Senator Mayquade yield for a question?
Senator Rasmussen.
Thank you, Mr. President. Would Senator Mayquade yield for a question?
Senator Mayquade, will you yield? She will yield. Senator Rasmussen.
Thank you, Mr. President, and thank you, Senator Mayquade. Senator Mayquade, could you talk about why the conference committee decided that we had to go from a 1% payroll tax cap that passed this body, and why in this conference committee report we've seen this now move up to 1.2%?
Senator Mayquade, to the question.
Thank you, Mr. President. To Senator Rasmussen's question, the House had no premium cap. The Senate came in at 1%. 1.2 was a compromise.
Senator Rasmussen.
Thank you, Mr. President. And I guess I'm disappointed that that's what the conference committee is sending back, because even with the 1% payroll cap that we passed in this body, that let this bill be wrong by more than 40%. Their estimate on how much money needs to come in through this payroll tax could be wrong by more than 40%, and they would still be fine with that 1% cap. What we're hearing from this conference committee is that they need to have the ability to be 70% wrong, Mr. President. And I think that's why it's so important that if we're going to set up a program like this for Minnesotans, we have to get it right. We have to know what the costs are. We have to know what the liabilities are for this program, so that we don't need to have a cap in here that allows for the math to be wrong by 70%. And this is one of the key concerns that I've heard from members in my community, from small business owners, from nursing home administrators, when they have the uncertainty about how much this is going to cost them and their employees. With all the uncertainty that we have from inflation, from all of the proposed tax increases from the Democrats this session, this is yet another tax increase and another uncertainty that we're going to be putting on Minnesotans, because we've decided we need to rush forward with this bill before we have the actuarial study done to know what those costs are going to be. Additionally, we see in this conference report, even though the Senate had a position that we were going to have some flexibility around seasonal employees, we see this conference committee report coming back and only going and only narrowly tailored toward the hospitality industry. And even then, there are many restrictions that I've heard from hospitality providers in the district that I represent, that they're concerned that they won't even be able to fit into this category. And so we're going to have potentially individuals who are taking on seasonal jobs who could have a benefit that actually outlasts their term of employment with the employer. And so, Mr. President, I had a question on this, and I was wondering if the senator from Moorhead, Senator Kupek, would yield for a question.
Senator Kupek, will you yield? He will yield. Senator Rasmussen.
Thank you, Mr. President. Thank you, Senator Kupek. You know, in our area, in the Red River Valley, we have a lot of agriculture. We also have a lot of hospitality with the lakes in our area. But I was wondering what I should tell individuals in the agricultural community who have seasonal workers, why they are now treated differently than hospitality workers in this bill.
Senator Kupek.
Thank you, Mr. President. Thank you, Senator Rasmussen. So when we were in the conference committee and we were talking with Deed, turns out when you have actually in our state statutes, we have a really nice definition of hospitality industry. And so that was an easier one to fit. And I was advocating also for some of the seasonal workers. The problem is when we said seasonal workers, Deed came back and said that there was a very large percentage of the Minnesota workforce, maybe up to 30% of the workforce, could possibly be excluded from this bill. And there are people within the agricultural community that we would like to also be covered by this, people who really work in that ag industry that are more in the full-time perspective of that. So I did, you know, and obviously being, you know, in an area that has a lot of sugar beet harvesting, I went and did a little research, contacted, you know, some of my people who do that seasonal work for those few weeks in the year there. And I think with actually some of the exemptions that are put in for small businesses who have a limited number of employees, that they will get actually a pretty decent refund back and get some of their stuff covered by the state. So the amount they will have to pay is not a great deal.
Senator Rasmussen.
Thank you, Mr. President, and thank you, Senator Kupek. And I guess, again, I would go back to why this needs to go back to conference committee. Right now in this bill, we're just looking at one industry and saying we're going to recognize the seasonal nature of one industry and exempt them, but from other seasonal industries, such as agriculture, that might have identical circumstances, identical seasonality when it comes to their revenues, when it comes to their workforce, we didn't take the time to make sure that we were including them and listening to their stories. And I think that's another reason why this needs to go back. We have in here a definition that talks about average receipts and how much it goes back to the preceding year. And in the area I represent, we have a lot of seasonal businesses. Some of them are in hospitality, but around the lakes and the lake cabins, we have lawn care businesses that might have very seasonal revenue, a lot of seasonal employees. From my reading of the bill, they don't fit into this hospitality definition. As the senator from Moorhead mentioned, with sugar beet harvest, and right now with planting going on and a lot of seasonal workers in the agricultural industry, from my reading of this bill, most of them will have to be paying into this program without perhaps ever getting benefits. And it's actually not just about the employer, it's also about the employee. This is coming out of their paycheck, it's coming out of their compensation for a job that they might plan on being at only for a few weeks for a benefit that they may never actually come to realize. And so, Mr. President, we've had debates on how we could offer more paid family medical leave to Minnesotans. Republicans have put forward good faith efforts on how we could do that while not having a multi-billion-dollar payroll increase that's going to fall on the employees. And no matter how you structure it, how you say employers are going to pay for this part, employees are going to pay for that part, this will come out of Minnesotans' paychecks. It will come out of the compensation that they see at the end of the month. And we're really dictating terms of compensation. And maybe we have employees that would prefer to have different structured benefits. And that's another reason this needs to go back to conference committee, is because we still have not put in enough flexibility for employers who actually offer more generous benefits than are in this plan. We've heard from a lot of employers who say, I offer benefits that are more valuable, but because of how this bill is written, unless I meet exactly the criteria laid out in this bill, I won't be able to offer those benefits to my employees anymore. Mr. President, this bill is just simply not ready. We don't know the math. We're hearing from the bill authors that they need the ability to be wrong by 70% on the tax rate. And additionally, we have work left to do on making sure that we're treating Minnesota employees and employers fairly and not just having a carve out for a single industry, but recognizing the seasonal nature of other jobs. And so I'd ask for a green vote. Let's continue working on this. And by the way, the effective date isn't until January 2026 for when this program is going to be up and running, so we have time to get it right.
Senator Kroon.
Thank you, Mr. President. I stand in support of the motion to reject the conference committee report. The primary reasons have been touched on a little bit. This bill isn't ready. Paid family leave is a valuable benefit, one that I support as long as it's a voluntary program, market-based program, and one that isn't a one-size-fits-all. This one is too inflexible, and it's going to be too expensive for the taxpayers. This bill just simply isn't ready, Mr. President. We haven't adequately examined the costs and impact on employees and government entities, Mr. President, cities, counties, school districts, who are also subject to this new plan. And it's irresponsible to pass this plan knowing that the taxpayers are going to get left holding the bag in the future when these costs predictably spiral out of control. But also, Mr. President, when considering whether to reject this conference committee report, this is one issue that also demonstrates that this bill isn't ready and it needs to be worked on a little bit more. In my role on the Judiciary Committee, Mr. President, one of the themes that I've had is I'm trying to point out legal concerns with some of these bills, constitutional concerns on a lot of these bills that are being rushed through the legislature. If for no other reason, just to save the taxpayers the cost of litigation that's going to ensue. There's going to be an avalanche of litigation after these bills that we're passing in this legislative session go into effect. And there's going to be some potentially serious consequences to our state for some of these bills, Mr. President. I've been talking about things like full faith and credit of the Constitution, extradition clause, the Second Amendment, the Fourth Amendment, federal preemption, negative federal preemption, the Dormant Commerce Clause. I spent some time on Friday talking about that. Now, in the bill before us today, we have potentially another example here, and it derives strictly from the conference committee report. Mr. President, railroads are explicitly preempted from state paid family leave bills under the Railroad Unemployment Insurance Act. And recognizing this specific federal preemption, states that have enacted similar paid family leave laws like this are specifically exempt the workers that are covered under the Railroad Unemployment Insurance Act. States such as New York, California, Colorado, and Oregon have all specifically exempted these employees. And so like those other states, when this bill left the Senate floor, it had specific language in it recognizing this obvious federal preemption issue. The railroads were specifically exempted from this bill in accordance with plain federal law that would preempt the federal law would preempt the state law. That language at the time in the Senate version said employment covered under the Federal Railroad Unemployment Insurance Act was specifically exempted. But for some reason, Mr. President, when it went to conference committee, the conference committee decided to remove this specific exemption language and replace it with vague language, which is on page 71 of the conference report. And this vague language, this general language, just says that nothing in this chapter shall be construed to be applied as to create any power or duty in conflict with federal law. Well, Mr. President, that's just nothing but a restatement of law. It isn't a specific exemption that should have been in there. So, and most importantly, Mr. President, I'm afraid that it isn't going to prevent litigation from ensuing. And it's just another example that this bill isn't quite ready, and it could use the benefit of going back to the conference committee to kind of to get some of these things right. But I hope that the intent hasn't changed, and it's just the language. So I'm wondering if Senator McQuaid will yield for a question.
Senator McQuaid, will you yield? She will yield. Senator Kroon.
Thank you, Mr. President, and thank you, Senator McQuaid. I hope the intent of the exemption hasn't changed, and it's just the language. So I just ask you if the language on line 71.14 of the conference committee report, is that meant to address the railroad's preemption of our state paid family leave bill?
Senator McQuaid.
Thank you, Mr. President. Thank you, Senator Kroon, for the question. If you look at 14.24, we have a definition of employee. An employee does not include employees of the United States of America. So you just went a little bit too far in there, which solves your problem. Oh, Mr. President, I will also add that there have been 0 lawsuits about this in the 11 other states that have this program, with the exception of Colorado, but it was about a tax law and it was struck down. So this is not a legal problem, and everyone's concerns can be calmed.
Senator Kroon.
Thank you, Mr. President. Well, unfortunately, I don't think that solves the problem, because a lot of these employees are not, the railroad employees are not employees of the federal government. They're not employees of the United States of America. So that exemption that I just heard has nothing to do with this conversation, Mr. President. And so I was wondering if Senator McQuaid would yield for another question.
Senator McQuaid, will you yield? She will yield. Senator Kroon.
Thank you, Mr. President. Thank you, Senator McQuaid. Do you know, Senator McQuaid, if there's been any conversations with DEED as to whether or not they have any intention of enforcing this bill on railroad companies and their employees?
Senator McQuaid, to the question.
Thank you, Mr. President. And before I answer the question, I'd like to request a roll call on this motion.
A roll call requested, roll call granted. Senator McQuaid.
Thank you, Mr. President, and Senator Kroon. The language that's on 71.14 is the same as in Earn Sick and Save Time, and it should calm your concerns that you're experiencing here.
Senator Kroon.
Thank you, Mr. President. And it may be the same language as exists in another bill, but that's probably because the language in the other bill is problematic as well. It doesn't solve my concerns on this specific bill. But, Mr. President, I am concerned, like I said, that this bill isn't ready. I think, as we've heard here, there are specific federal preemption issues that they were addressed in the Senate position. The Senate bill had this in there. I have not heard any reason why it was stripped out and replaced with this vague language. I was hoping that we'd get some assurance that it doesn't, that there is no intention of applying it to the railroads. But, Mr. President, I think there's going to be some litigation on this issue that ensues. And even if, Mr. President, DEED chooses not to enforce this provision, the employee has an appeal process, and a hearings judge could add it back on. So even with DEED saying we're not going to do it, even if I didn't hear that today, but even if I had, that still doesn't alleviate the concern of litigation. And, Mr. President, that's going to lead to the taxpayers having to defend litigation that they wouldn't have had to pay for if this bill had been more thoroughly vetted. And Mr. President, the other concern I have that relates to this conference committee report, specifically whether or not we should vote to reject it, is the Senate version. And these were amendments that I was able to get on in Judiciary Committee through amendments that had bipartisan support for these amendments, and that is the rights of appealing an eligibility determination by DEED. And the way the bill was initially drafted, it only allowed for an employee to appeal that determination. It did not allow for an employer to appeal that determination. And I brought an amendment in Judiciary and was able to successfully get that amendment on to make it clear that an eligibility determination could be appealed by both the employee and the employer. Now, the employer has appeal rights later on in the process if an employee has been aggrieved and it goes to a hearings judge and the employee loses, or the employer loses there, they can appeal it at that point. But there is no avenue for an employer to get into the system unless it goes way down the process. But there's no way for an employer to appeal an eligibility determination. And that's very problematic. It's very one-sided. And there are serious penalties involved with this with this bill as well on employers. So it's very realistic and likely that in some scenarios an employer is going to have relevant information on that eligibility determination, and they should have a right to participate in that process and have an appeal. Mr. President, I was also able to successfully add into the bill through an amendment something that said specifically that this shouldn't be controversial. It says the commission, in the Senate version, it said the commissioner must provide an opportunity for the employer to submit relevant information. Very innocuous, very common sense, and again, it's received bipartisan support in getting that amendment put on to the Senate version, but then when it went to conference committee, it was stripped out. So right now, there is nothing specific in this bill that would allow employers to even submit information that might go to the very heart of the eligibility determination. And those are just a couple very small examples, Mr. President, that regardless of where you stand on this bill and what you think about it and what you think the government's role is in providing paid family leave. And like I said, I think it's a worthy employee benefit. I support it in a way that can be both beneficial, more beneficial to employees and certainly more beneficial to employers, that will not crush small businesses. But regardless of where you stand on that, these are just a couple provisions to show that this bill isn't ready and it needs to get back to the conference committee for additional work. Thank you, Mr. President.
Senator Bowden.
Thank you, Mr. President. I rise in opposition of the motion to send this back to the committee. We've had some conversation about the cost and the potential local impact of this bill and this legislation, and there is a cost and a local impact, and I want to focus us on the human cost and impact of not passing this bill, because there is a significant one. I want to share the story of one of my constituents, Tony, who her mother was in a senior living care facility during the pandemic and was diagnosed with cancer. She opted to not have further treatment for her cancer, and because of that needed more care and was transitioned into a long-term care facility. Tony had several siblings, and none of them had paid family medical leave. And so while their mother was in a care facility dying, they tried to cobble their work schedules together so somebody could be there with her, but they couldn't. They could not take time off of work. They all had families, responsibilities, children. They could not afford to take time off of work and cobble their schedules together to ensure that somebody was there with their mother. And so in the end, because the nursing facility was also short-staffed and not set up to have one-to-one care for her mother, her mom died alone. And so that is the local impact. That is the cost of not passing this bill. And I just want to share a quote from Tony, who says, "I just feel like I failed her because she had a miserable, miserable death and did not have the attention she needed. This year, paid family medical leave has got to pass because my siblings and I would not have been juggling our work schedules. We would have been taking time off to care for her." So members, this bill has been around for years, 11 years. We don't need more time. We need to pass this bill so Minnesotans don't have to choose between a paycheck and being able to take care of themselves or loved ones. So members, let's pass this bill.
Senator Abler.
Thank you, Mr. President and members. I was happy to see one part of this bill that left, and if I'm going to ask Senator Makeway to yield in a second. One of the concerns I've had is about what happens in the long-term care side with nursing homes and assisted livings, and I think the cost of that is considerable. In the budgeting, I don't have a precise number, but it's certainly in the tens of millions of dollars a year on this industry. And this industry is dependent entirely on funding from us. As we just are wrapping up our human services omnibus, that topic comes up a lot. And so if Senator Makeway would yield for a question, Mr. President.
Senator Makeway, will you yield? She will yield. Senator Abler.
Well, thank you, Mr. President. Senator Makeway, when this bill left the floor, there was some funding in there for the employee share of this of the paid family leave. Can you please comment about if it's still in there, and did that language or anything change in the conference process?
Senator Makeway.
Thank you, Mr. President. The money did not leave, but I will defer to Senator Mitchell to describe a little bit more. Excuse me, I'm sorry, Mr. President. To defer to Senator Mitchell to describe a little bit more about the rest of it.
Mr. President.
Senator Abler.
Thank you, Senator McQuaid. Would Senator Mitchell yield for a question?
Senator Mitchell, will you yield? She will yield. Senator Mitchell.
Did you hear the question? Did she hear the question, Mr. President?
Senator Mitchell, did you hear the question?
I did hear the question, Mr. President.
She heard the question. Senator Mitchell.
So I think this is one of the really wonderful things that we were able to do with this. I don't recall if Senator McQuaid mentioned this or not, but one of the things that we have done in this is to take $668 million of our budget surplus and use it to help fund this program in general. So startup costs, money to get this off the ground so that that first year or two as people start to pay in, we already have a pool. So what we are doing specifically to the direct care workers, which Senator Abler, I share your concern with this, is that of that larger number, $20 million is going to be directly set aside for that. Now, there is actually a fiscal note. I heard someone say that there wasn't a fiscal note, but particular to this subject, there is a fiscal note, and it looked at how much the nursing home rates would need to kind of offset this. So that would be about $200,000 is what the first year cost is, because it might be a partial year, and then possibly $1 million after that. So there's already a big pot for that to start drawing from in the first place, and then there is a commitment from DHS that those would end up being reimbursables going forward for the nursing home. So, and then the other thing with this is, and part of this is in the Human Services bill, which I know you worked very hard on, Senator Abler, which, Mr. President, I know that Senator Abler worked very hard on. But there's also another, I believe, $90 million that is retention for those direct care workers that includes retention money, help with daycare, transportation, hiring. So the combination of the way that we are able to add in this paid family medical leave being covered and then also retain those valuable workers in other ways, I think is going to be a huge boon to drawing more people in to caring for our disabled, for our elderly, things of that nature. Because, you know, as we heard when this first came through, a lot of those workers happen to be female. A lot of those workers happen to be minorities. And so, for example, you know, Senator Gustafson told a compelling story about when she didn't have this leave, she didn't happen to be in this career field, but without having this leave, how she had to go back to work still bleeding after having a child, and how many women end up re-hospitalized after giving birth if they aren't able to take proper leave. Another story that Senator Mann told that was so compelling about her treating someone in the emergency room who had a job where they had to be on their feet, very similar to what many of these direct care workers have to do, and how that person had an injury that was going to take him off his feet, and he was crying because he didn't know how he was going to pay the bills. So I actually think that this paid family medical leave is going to be a tremendous benefit that will help people in the direct care, but both with the initiatives in Human Services and this committed chunk that is going to go to paid family leave, and also the fact that DHS has already done the analysis, that DEED has looked at this financially, and that if we need to put more money in at some point, we have a commitment to continue to do that. But I think all of those things really have this for our people who take care of those who take care of us in a really good position. Thank you so much for the question, Senator Abler.
Senator Abler.
Well, thank you, Mr. President and Senator Mitchell, for that answer, and covered a lot of ground in that answer, which is fine. And so I'm glad there's some money in there. I was just reading the bill. I'm just trying to figure out what it actually said. So maybe you can help me interpret this. And you singled out nursing homes, and I'm certainly concerned about their welfare. So I'll just ask, would she yield for another question, Mr. President?
Senator Mitchell, will you yield? She will yield. Senator Abler.
Thank you, Mr. President. I don't have the privilege of having the fiscal note here. I just have the language that's in here, and there's a lump sum of $20 million, which seems that it may be added to the base for all these 300,000 home and community-based workers. And there's nobody, I think the whole body here wishes they could somehow be covered by this. So, but the question is, Senator Mitchell, is that money you mentioned, the million something and all that, is that for the entire share? Or is that simply the employee's share, as I thought it left the floor with paying the employee's share? Has this now been expanded to cover the entire share at the particular nursing home? That's because she mentioned nursing home specifically. Thank you.
Senator Mitchell, to the question.
Thank you, Mr. President. Thank you, Senator Abler. So all of this is covered under Section 60, which is the Long-Term Services and Supports Workforce Incentive Fund grants. So under that, the Commissioner of Human Services establishes grants for the long-term services and facilities to assist, as I talked about, with recruiting and retaining direct support professionals. Those eligible employees, that means organizations enrolled in a Minnesota healthcare program, includes providers of home and community-based services, facilities that are intermediate care facilities for developmental disabilities, nursing facilities, personal care assistants, first services, and there's a number of other things listed under that. I also want to add what this costs in general, because that is something I had wanted to speak to anyway, and I think it's very relative to this particular part of the conversation. But even if someone doesn't have an employer that covers the whole cost, or if they have to have a share, this breaks down to someone that is making $50,000 a year. And we do know these numbers because the United States is almost the only industrial country that doesn't do this. So we can look to other countries, and 11 other states are now already doing this. We're starting to kind of get behind on the fact that we should be doing this. But so we do have a lot of numbers. And so if someone's making $50,000 a year, for example, the breakdown is under $7. So if that was to be split by not someone covered under this, the direct care, which we already talked about, but split by an employer and an employee, we're talking $3.37 a week is the estimate. And so for an employer to say, you know, this is going to bankrupt our business, or we're going to have to cut other benefits, over $3.37 a week? I just have problems seeing that would be an accurate statement. But again, Senator Abler, back to your question. Yes, we are doing things to both incentivize in this bill and in other ways all of those direct care facilities. And as I mentioned, there's just a whole list of direct care agencies that would be eligible for the grants so that they wouldn't have to pay for this, and DHS's commitment to make that a reimbursable if for some reason they did at some point.
Senator Abler.
Well, thank you, and I appreciate both very expansive answers, which actually my question was much simpler. But I was looking for Section 60 in this bill, and there isn't one. And I'm just thinking maybe Senator Mitchell was reading to me the Human Services Section 60 in Senate File 2934. So maybe Senator Mitchell would yield for a question like, where are these grants that you're talking about?
Senator Mitchell, will you yield?
I will yield.
She will yield. Did you hear the question?
Yeah, so what I just read off was, I believe, Section 60?
Mr. President, there's not a section.
Senator Abler?
There's not a section, like what page in line would that be, Senator? If she would yield, so would she yield to answer?
She says she would yield. She's waiting to yield. She wants to just make sure that she understands your question.
Mr. President, where in the conference report of House File 2 is that section that Senator Mitchell is referring to?
Senator Mitchell, did you hear the question?
I did. It is
All right.
Article 3, Section 11.
Article 3, Section 11. Senator Abler.
Okay, yeah, page 80, so section 11.
Section 3.
Yeah. It's actually section 11, Mr. President.
Well, she said Section 3. Article 3, I'm sorry. Article 3, Section 11.
Yeah, well, okay, Mr. President, there's no detail listed on here, so maybe she knows something I don't know, but it says 20 million is added to the base appropriation to the commissioner to provide reimbursement for premiums incurred for the paid family.
Senator Abler, can I ask that you move the mic up?
yeah.
Because it sounds like you're thinking out loud, but we want to hear your thoughts.
Thank you, Mr. President. It's not always good that our thoughts that we are thinking are out loud, so I appreciate that you can differentiate those. I am trying to ask a question. Thank you. So it says here that talks about $20 million, and it's for premiums, and it just says it's going to go through this community-based workforce incentive fund. And maybe that's what you were reading to me. But my question is this, and I wasn't hoping to get, your answer was fine, and people working should certainly be able to work and take care of their families and everything, which is the point of the bill. But so the money in here, the $20 million that starts in 26, which I believe is ongoing, does that intended to cover both just the employee share, or because that's where I think it left the floor, or is this also now cover the entire share for all 300,000 workers in this niche? If Senator Mitchell would yield and answer that question.
Senator Mitchell, will you yield?
Yes, I will yield. And
She will yield. Did you hear the question?
Yes, Mr. President.
Senator Mitchell.
And I would like to apologize because when I said Section 60, some of this specific language that Senator Abler is talking about refers back to the Human Services bill because they're interlocked in how this money is going to work, refers back to that bill. So there is language in both bills. But so the employer versus the employee, this is set up so that all premiums are to be paid by the employer. Now, this is in general, who can then charge up to half of the employee. So just in general, that was that $7 off of, if a person was making $50,000 I was talking, and then it could be split, which was the $3. So the current language would have the employers seek premium assistance, and they can use that. So they can put in for that assistance, and instead of using that option to back charge half to the employee, they can have that covered. So in that case, then the employer of something that did the direct care would just pay the full $7, and then that $7 would be eligible for the original 20 million lump, or what DHS had said would be reimbursable. So by that way, the employee would not end up getting charged, and no employer has to charge their person under this. Again, on the $50,000, they could just say, we'll pay that full $7 a week because we want to do that for our employees who we value so much.
Senator Abler.
Well, thank you, Mr. President, and I appreciate the discussion, and I'm really not trying to drag this out, but it's actually raising more questions than I had. I just looked up section 256.4764, and that section does not exist. And maybe it's in the Human Services bill as a pending thing. So the pending number in the conference report's out, and assuming it passes that section, will exist. I was just interested, if that really is from that bill, it's interesting we're about to pass legislation that references a section that's pending in a different piece of legislation, and that's a whole different discussion that I'm not going to do that to you, Mr. President, to ask about that. That would be most curious. But if that's the case, that's kind of interesting. Because it says that's how you're going to maybe pass it out. But anyway, so just since you brought up that fund in the other bill, Senate File 2934, it's $90 million, it's one time, and it's available for all kinds of purposes to workers, and it may not even be, there may not be any money left in it by the time we get to 2026 when this is going to be needed. And we talked about it in conference, and it may take 6 months to a year to stand it up, and I have a feeling that that money is going to go out the door quick because nursing homes and other places are in such straits. And so I don't know, Mr. President, and for the people who are going to implement this thing, you might want to figure out how this is going to work, because I think this is a gap in legislation, which I'm not going to pursue. So, Senator Mitchell, the question I asked before, and let's pretend there's no other fund because it doesn't exist yet. Just out of the $20 million, is it the intention of the legislation to pay the employee share through whatever mechanism, reimbursement or otherwise, as the sole part of the fee of the tax? Is that what it's called? So the 0.7 to 1.2%, that the employee is bound but to pay half that, so 0.35 to 0.6. Is this intended to cover the employee share of this tax?
So you're asking Senator Mitchell to yield?
Mr. President, will Senator Mitchell yield?
Senator Mitchell, will you yield? She will yield. Did you hear the question, Senator Mitchell?
Yes,
All
Mr.
right.
President, I heard the question. I tried to follow the question as closely as possible. I feel how I heard the question was something I already answered, which is that the intention for direct care workers is that the employer would pay the entire, because the employer is going to get reimbursed. So they would not take the option employers have to split the cost 50-50. They would instead keep the 100% of the cost, and then that cost will be reimbursed. I hope I understood that question correctly, but if I did, that would be the answer.
Well, thank you, Mr. President.
Senator Abler.
So what I was, and so that, and I'm sorry if I'm dull today, but so I believe the answer to the question is this $20 million is meant to pay through a reimbursement mechanism, which is actually often delayed, the employee's share of this through a reimbursement mechanism. And so I believe then so I don't want to drag this out, but so Senator Mitchell, it's not the intention of this $20 million to pay the 100%, but to simply reimburse for the employee's share. I think I've got that right, and then I have a question beyond that, but if you can just nod it's not the intention to pay the entire tax of a particular nursing home on this. It's meant to reimburse the half that would be payable by the employee. I think I said it clear, and you can just say yes or no if you'll yield, Senator Mitchell.
Senator Mitchell.
Yes,
Yes, you
you
will
did
yield.
not. I'm not sure what to do. Yes, the intention is to pay the employee share.
Senator Abler.
Thank you, Mr. President. And so would Senator Mitchell yield again for a question? I bet she will.
Will you yield, Senator Mitchell?
Yes, Mr. President.
She will yield. Senator Abler.
Well, thank you, Mr. President. It's nice that the committee can be involved in a human services discussion. That's always a good opportunity for anybody who doesn't get to serve on the committee. On line 80.24, it says it's added to the base appropriation. And so, Senator Mitchell, does this include, is this ongoing when it says added to the base appropriation, or is this $20 million added one time into that fund? If she will yield, Mr. President.
Senator Mitchell will yield. Senator Abler. And Senator Mitchell, did you hear the question?
I did, Mr. President.
Senator Mitchell.
Hold on. Mr. President, so it is currently one time. Again, even though we have a lot of data from other countries and other states, we want to look at what would be appropriate for this. So it is currently one time, but the legislature legislature can choose to make it ongoing in the future, because I know that once this gets going, there is an intention to do another actuarial of the first year to see what the actual costs are and if there needs to be any sort of a reassessment.
Senator Abler.
Well, thank you, Mr. President. And actually, I had read it wrong. I thought it was ongoing, and I appreciate that clarification because it left the floor as one. And so, you know, on this motion to not concur, I think this really needs to be funded permanently if we're serious about this. To that point, I think it should go back and they should pay the bills that they're going to be having people incur. By contrast, Mr. President, I don't know if it was in this version or the other one, but the different agencies are getting money every year to cover their costs. Labor and Industry, Commerce, MMB, ironically, Human Services. It's getting ongoing base funding. Secretary of State, Supreme Court, and even the legislature gets something. I don't know if that's ours or for our staff. And the U of M gets ongoing funding. Mr. President, I do appreciate the discussion. I do want to point out something and why I think this should go back. And Senator Mitchell, I appreciate all your passion. I appreciate very much, I mean, you have a way of bringing the humanity into it and telling a story about an individual or a family that compels me to want to support paid family leave as well, and to make sure that those individuals who are making $50,000 or less, barely getting by, want to take some time off to care for their daughter or sister or spouse or loved one or whoever, so they can care for them. But Mr. President, the way this is set up, given even the interactions with the current human services legislation that's before us, that this is going to create a $60 million additional expense into the system of all the whole human services systems. And so if you've heard Senator Hoffman say anything, that he felt the target was insufficient to handle the needs. This is going to play, if this covers indeed the share of the employees for 1 year and then the costs are ongoing, there's $20 million more that has to come out of whoever the nursing home is and the other places. And then in the upcoming year, it's going to be $40 million. Now, Mr. President, we had a story about, you know, Senator Mitchell had a really just compelling story, and I just makes me just feel happy that maybe there's something we can try to do. But Mr. President, I don't know if you're aware that many of the nursing homes, group homes, day facilities, home care agencies, et cetera, are on the ropes. They're barely open. Nursing homes, 10% are on the verge of closing. 50% are burning into their reserves. And so in the budget bill that's about to pass, you'll be asked to vote on, there's $100 million in loans for nursing homes, $2 million for critical access, and then this $90 million pot to help deal with with all these fine benefits that would go to the workers. But Mr. President, none of that is permanent funding except for $2 million for critical access facilities that's going to be increasing the funding of these places. So Mr. President, what does that mean? As one of my superintendent friends told me, we're going to have better benefits, but for fewer workers. And so the story that Senator Mitchell told is accurate and will be helped by this. But Mr. President, because of this impact of $60 million just in one biennium, and then $80 million bienniums going forward into 28, 29, and 30, 31, et cetera, there's no funding to pay for that. And it was the opinion of the governor and others that there was adequate funding in the nursing home bucket and in the home care, et cetera, buckets. And as a conference committee, we disagreed and put some significant funding into it. But there's not hardly a penny of new money going to nursing homes that they can just spend as though it's cash. When the bill left the floor of the House, of the Senate, there was ongoing money. And so it isn't as though these nursing homes are some big corporate empire. These nursing homes are run by local citizens in most cases. Most are nonprofits, and they're closing. And so the grief that Senator Mitchell's story talked of is real. But Mr. President, the grief that a family experiences when they can't put their loved one finding a bed for somebody who needs rehab post-surgery, or they have a stroke and they need somebody to attend to them 24/7. They've been helping their mom and they can't do it anymore, and they're looking for a nursing home bed. Mr. President, because of the impact of this very paragraph, where we're going to be taking $60 million of additional burden, well-intended and a good value, but without paying for it, then that adds burden without any opportunity to pay. And some of the very people that we are hoping to improve the lot of, that Senator May Quaid is passionate and rightfully so about, and Senator Mann, as I've heard her talk about, let's help these individuals. Mr. President, they're going to be unable to maintain the job that the person has now. And so it's one thing to be able to handle your own individual needs. It's something else to not even have a job to go to at a company that wants to help. And they want so much, Mr. President, that they are taking out loans and digging into their reserves to try to keep their system intact. And ironically, some of the loans that are in Senate File 2934, which have been referenced in this bill, the companies are so loaned up and they've mortgaged even, they've taken out personal loans to keep it open, they can't take out any more loans, they're forbidden. So this should go back, Mr. President, and Senator Mitchell and Senator May Quaid, and I know you mean well by this, but if you mean well on this industry, you need to find $60 more million, and then I would have had nothing to say on this bill, on this topic, but Mr. President, it is not going to be adequate. Yesterday when I called up one of my facilities in my area that does services through disability, I said, good news, there's some good money coming to you in Senate File 2934. However, just so you know, there's a sick time thing, which is going to cost you about 2% because you don't afford that. You would like to. And then there's this nominally 0.5 to 1%. And she goes like, what? And so, Mr. President, you want to mean well. And as I read all these letters from the groups that are just, they're spot on, Mr. President. They recognize the need, they recognize the value, but it's really more like wouldn't it be nice, Mr. President, in college, that was one of my favorite songs by the Beach Boys, wouldn't it be nice? And so, wouldn't it be nice if? But then you have to figure out, wouldn't it be nice how? And the discussion we had on the floor leaving here was about this very matter, and it didn't get resolved in conference. And at a time when there's $17 billion of surplus, wouldn't it be nice, Mr. President, if we could fully fund the nursing homes and the group homes and the day facilities and the home care and the very core of what it is that we rely on for the needs of our elders and our seniors and those with disabilities? And Mr. President, I'm not trying to be unreasonable here, but this has to go back. You need to find the money. We need to set a priority. There are so many elements of $60 million that have been squandered on things that are not essential, they're not important, they truly are nice. And so it's up to us to judge what's essential, what's important. Mr. President, this is essential. It needs to go back. Please, rejigger the money. I'm not in charge of that. Let's fix it. Thank you.
Members, before I go to my next person, let's be clear. When you ask for someone to yield, I'm doing a number of different things, but I have to ask that person if they want to yield. Some people may think it's clear that they want to yield, but they have to respond to me, because sometimes you're sitting there and if you're not saying anything, then I can't just assume that you want to yield, because a member always has the right to say, no, I don't want to yield. So just so that we're clear, Senator Farnsworth, I'm sorry.
Thank you, Mr. President, and I stand in support of Senator Draheim's motion. And I support the motion. I support his motion to send this back to committee because I think this bill needs work. And I want to make it clear that this is not an indication that I don't support the idea of paid family leave, because I think that there is a solution to this problem that we could work on together that would have much more meaningful impact. And Mr. President, people know that I have 4 children, and 2 of my wife's pregnancies, she actually was on bed rest. And of course, we were lucky that my wife was part of a collective bargaining unit and had certain benefits, and I would pick up any job, whether it was painting or rehabbing houses, to try and pay the bills when she was home unable to work. And I understand that that poses a certain challenge to a lot of people. And so I think we need to get this right. And so this needs to go back. And there's a couple of things that I want to talk about. And I have the honor of representing the Iron Range. And as you know, I am trying to fill the shoes of a legendary senator, Senator Tomassoni. I wish that all of the new people here in the Senate had the opportunity to get to know Senator Tomassoni, because he was passionate about the range, and I think he was probably much more eloquent in his support and defense of the range. But I guess I'll do my best. And through the years, I have gotten to be much more proud about the legacy of the range, and hopefully, Mr. President, with your term on the IRRR, that you will also become as proud about the heritage of the Iron Range that I am. And the pride that I have not only goes to the fact that the Iron Range produced the steel that built skylines across America, the steel that won 2 world wars, produced the steel that provided my family growing up a good living. But in addition to that, most people maybe don't realize that the legacy on the Iron Range is also a legacy of collective bargaining. And in the early 1900s, the immigrants that worked in the mines were working 12 to 16 hours a day, 6.5 days a week. And they fought for the 8-hour workday. They fought for better wages and better working conditions. They fought for a contract that their members wanted. They fought for benefits that their members wanted. And the fight that they fought on the Iron Range was also fought in Ohio and Pittsburgh at the steel mills there. And that has reverberated through our culture, through America, and it's turned into better working conditions and better pay for, I think, most Americans. And so I wonder if the senator from Apple Valley would yield for a question.
Let's see, who's the senator from Apple
Senator
Valley?
McQuaid.
Senator McQuaid, I thought so, but she is not there.
Thank you, Mr. President. Somebody else who knows the bill, would the senator from Woodbury yield to a question?
You know, so interesting that we do these cities, and now you want me to go through my Rolodex and try to figure out where everyone's from. Let's try those names from time to time. Senator Mitchell, will you yield? She will yield. Senator Farnsworth.
Thank you, Mr. President. And to the good senator from Woodbury, I am wondering, and I know that you know this is a big bill, and you may not have the answer, but I'm wondering, is there an option in this bill for organizations that have a collective bargaining agreement to opt out if they choose, if they decide that these aren't necessarily benefits that they want or need?
Senator Mitchell.
Mr. President, I would love to take a stab at answering that question. I know most of it, but Senator McQuaid has returned, and I think she would be the better person. I am impressed that Senator Farnsworth knew what city I was. So.
Well, now you're making me feel bad that you're impressed with him and not impressed with me.
I'm impressed with you all.
I'm just messing with you. Senator Farnsworth, are you okay with going to Senator McQuaid to the question? She's returned.
Yes, Mr. President, do I need to repeat the question?
Yes, she's nodding yes.
So, Senator, the question is there an option in this bill for organizations that are part of a collective bargaining agreement to opt out of paying into this and meeting the demands of this bill if that's what the collective bargaining unit would like?
Senator McQuaid.
Thank you, Mr. President, and Senator Farnsworth. A bio break. Collective bargaining units can opt out. Certainly their employers can if their private plan meets the basic thresholds. And employees and employers can work together to bargain around a stronger program if necessary.
To the good senator from Hibbing.
Thank you, Mr. President. I'm about a third of the way through Masons, and at one point as I've been reading through Masons, it does say that we're supposed to attempt to address people rather than by name, so that's why I've been practicing that. So back to the union part. A little bit of my history. So my dad was a 33-year union member. He grew up in foster care in the state of Maine. After going to college for about 2 weeks and deciding that that was not for him, he joined the Air Force for 6 years. And after getting out of the Air Force, he was able to get a job at the mines where he worked, supported a family. And what that meant to us is that he worked shift work, he worked midnights, he worked holidays in order to provide for a family. And he was able to do that because of the rights and the benefits that they have negotiated in his collective bargaining unit with the steelworkers. Mr. President, a lot of people don't know that I have been a union member for over 25 years. I started in the commercial foods union pushing carts at Super One Foods, and I've been in Education Minnesota for years. And in that role, I've been local union president when I was teaching with the Department of Corrections, and we have fought for some of these same benefits. And the thing that that has occurred to me, Mr. President, is that there may be people that are in collective bargaining units that negotiate for benefits that work for them. And those benefits might not look like the benefits that are in this bill. For instance, Mr. President, with the Hibbing School District, I'm allowed to bank sick days. And I think I'm up to about 120 sick days that I have banked. And so if I have a serious illness or if a family member has a serious illness, I can use that time. And that's a benefit that we've worked out with the employer. And I think it's a good benefit. If I don't use those sick days, then I get to cash those in when I retire for a severance. And it occurred to me that this legislative session, the legislature of the state of Minnesota is trying to act not only as the state school board by mandating all of these things in education, but we're also trying to act as the state collective bargaining unit. And Mr. President, I pay about $85 a month in union dues. And why should I pay that $85 a month in union dues if the state of Minnesota is going to negotiate all of the salary and benefits and everything that my union is negotiating for me? Speaking of schools, Mr. President, I've been talking about the impact of these unfunded mandates on schools. Interestingly enough, I've been giving numbers about how these different mandates are affecting school districts. Now, I just looked at those numbers, and actually those numbers where school districts will be underwater does not include this paid family leave. So I'm just going to review some of those that I've mentioned and some that I haven't. A Mesabi East School District, without the impact of this paid family leave, will be $2.3 million. Now, again, that is without the impact that they are going to have to pay for this bill. Mountain Iron Buell School will be $1.3 million. Aiken Schools, $536,000. Greenway Schools, $1.295 million. The Nashwauk-Keewatin School District, $581,000. And St. Louis County, $2.7 million. And that is without the impact factored in of this bill. Mr. President, this needs to go back to the conference committee so that we can have some exemptions for folks in collective bargaining units. And the last thing I want to say, the co-author of the bill in her early statements made the statement that this is a small business issue. And how do we know, Mr. President, that a bill is not a good bill? We know because everybody will say, well, yeah, you can pass that, but please give us an exemption. And every single business that I have talked to have said, hey, fine, go ahead and do it, but give us an exemption. That's how we know that this bill needs work. I have not received a call or a text or an email from any small business in my district asking for this, but I have received dozens of calls and emails and mail to my home even begging us to not do this. So, Mr. President, protect collective bargaining rights, protect our small businesses. We need to send this back to the conference committee so that we can get it right for the people of Minnesota.
I'm calling now the good senator from Woodbury, Senator Mitchell.
Thank you, Mr. President. I had already been on the list to speak, and then with questions, I was able to actually mention a lot of the things that I wanted to, but I think this is an amazing bill, and I'm going to hold comments because we're not on third reading quite yet, but there were questions I do want to clarify. So I was answering, for example, very specific questions about the direct care. Yes, sometimes how we have to fund things and set up accounts and everything else is complicated. But the short answer is it is being funded. It is being reimbursed. And we talk a lot about the employers. Not only in this particular case are the nursing homes and the companies that manage these care workers going to get reimbursed, but worker after worker after worker lined up and said to us, this would make me be able to keep my job. When my mom got sick and I had to take care of her and I made a choice, or I had something happening with my family and I had to juggle childcare, this will help us retain all of these workers who are having to make that dramatic choice between a job they love, including caring for our disability and caring for our elderly, and having to take care of their own family. So, yes, for direct care, there is a reimbursement frame set up. The question was about a one-time fund that could be refunded, but it is still worked into the reimbursements. So let me be clear, we are not going to be hurting our nursing homes with this. In fact, we are going to be helping them because this is what their workers want, to retain themselves and make their work more equitable. And just in general, I want to reiterate, this is a small cost. This is set up like insurance. So everyone pays a little bit in, and then heaven forbid, if you're that person, like I mentioned I was, who finds themselves traumatically having something you never expected, where all of a sudden you can't work, then insurance has borne the cost, at a little cost to everyone, instead of you losing your home because you're not being paid. Especially when people, if they have a traumatic medical issue, already likely have big medical bills on top of it. This is going to help our workforce, and this is especially going to help our people. I will leave it at that, but this has been through committee, and it hasn't changed that much. I think a lot of people here have already made up their mind, and even if we sent it back and it came back, I think we're going to be at where we are today. So let's be realistic about this, and I think the committee did a great job. Thank you, Mr. President.
The good senator from Park Rapids, Senator Uckey.
Thank you, Mr. President. You're getting your geography lesson now, aren't you? But, before I get into a couple questions, I'll make a couple comments, and I've got some questions for the author. But I've heard a couple of things stated here just over the last hour or so. A couple of them being, one, the bill's been worked on for 11 years, or it's been in the system for 11 years. That doesn't mean it's right. This still has a lot of flaws. There's a much better way to do this so that businesses can offer it as a benefit and still survive. Also, I've heard the comment about it's a small cost. When you run a business, it seems like there's 1 million of those small costs that show up in the mail each month that you've got to pay. And those small costs end up to be sizable amounts of money at the end of the month, at the end of the year. And it's all about being able to pay those employees, keep the lights on, and provide the services that you're there for. And that's why this needs to go back to conference committee. We need to be respectful of those businesses. The employees are their most valuable asset. I've said that the last time this bill came before us. There's very few businesses that are single owner operator. We've all had employees, and we know how valuable they are, but we have to be able to make this system work. The state mandating these things on our business, how we're going to work with our employees is just absolutely wrong. But I do want to go into a couple questions, Mr. President, if I could, that I have for Senator McQuaid, if she would yield.
Senator McQuaid will yield. Senator Uckey.
Thank you, Mr. President. Senator McQuaid, got a couple things within the bill here, and the first one I want to ask is just for clarification. Under seasonal employees, I'm looking at some of the hours or the days that they could work. And then it also talks about the percentage of business that would be done during those months versus the rest of the year. And in particular, how would resorts be affected by this? In my area, there are a lot of resorts. That's maybe a 3. Somebody's got a little bit of a shoulder season, 4 months at the most. It's a very compact season. Are those employees exempted?
Senator McQuaid to the question.
Thank you, Mr. President. And to the good senator from the place I did not catch, and I'm going to get a good geography lesson too.
Park Rapids.
Thank you, Mr. President. The good senator from Park Rapids for the question. You know, the good senator from Park Rapids began with this question by talking about the flaws in this bill, and that we need to be respectful of those businesses so that they can offer this as a benefit and still survive. This keeps getting lost over and over and over, Mr. President. This bill is about Minnesotans. It is about people who work, who are constantly being asked to choose between healing from their cesarean or paying their rent. Or like me, healing from their cholecystectomy, ironically, or paying their rent. Bonding with their baby or making their mortgage. Getting cancer treatment or keeping their health insurance. We need to be respectful to Minnesotans. Without paid family medical leave, people literally die. Part of the reason that we have some of the highest maternal mortality morbidity rates in the United States is because we are the only industrialized nation that does not have guaranteed paid leave. So let's talk about those we want to survive, literal people. To the question about seasonal employees. To the good senator from Park Rapids, Mr. President, I can't give a specific answer because I'm not sure what specific organization he's talking about, but the definition is quite clear. It's pulled from the Fair Labor Standard Act. And so if they have employees who work for 150 days or less in a 52-week period, and they earn not more than 33% of their average receipts in 6 months of the year, so if they earn a bunch of their money in a short part of the year, then they would qualify to apply to have their seasonal employees be exempt. So that would be the answer, and that's up to each individual business.
Senator Aki.
Thank you, Mr. President. And I was trying to follow that, but did Senator McQuaid would yield?
Senator McQuaid, she will yield. Senator Aki.
Thank you, Mr. President. Senator McQuaid, did you say there was an exemption process they could apply for that short term?
Senator McQuaid, to the question, when you're ready.
Thank you, Mr. President, and to the good senator from Park Rapids. Most resorts will be exempt, Mr. President, so that is part of the answer, but then there is criteria here, and they'll have to submit an application to the department to be exempt from the premium collections.
Senator Aki.
Thank you, Mr. President. And thank you, Senator McQuaid. If she would yield for another question, Mr.
Senator
President.
McQuaid, will you yield? She will yield. Senator Aki.
Thank you, Mr. President. Senator McQuaid, now I jump back, page 71. It's got small business assistance grants. It appears that businesses would be available to apply for a $3,000 grant. Is that to cover all employees then? I'm just looking here quick. I didn't remember when I highlighted it. But they could apply, and these are businesses with 30 employees or less, but they would have that ability to apply for a refund?
Senator McQuaid.
Thank you, Mr. President and Senator Aki. So the small business grants and premium reduction, it provides business grants up to $3,000 to employers who have 30 or fewer employees and less than $3 million in gross receipts. And so these grants can be used to hire temporary employees or cover increased wages if, say, one employee is getting a raise because they're covering the work of the absent employee. Up to $5 million a year can be expended from the account for this, which, if they took the maximum benefit, would cover 1,660 small businesses in the state of Minnesota.
Senator Aki.
Thank you, Mr. President. Thank you, Senator McQuaid. You know, we've heard a lot of different numbers here today so far, and it just kind of shows what the cost to both our businesses and our citizens of Minnesota are. There was a $658 million front load fee. That's our taxpayers all paying in on that, money that they expected back in tax relief, but it's for startup of this program. I heard another number of 90 million. We heard discussion earlier about the 20 million for the employees in the long-term care field. It just shows how expensive this plan is. And those expenses are all going to fall back on our businesses, of which fall back on our employees. Because if the business cannot afford its bills, it can't keep its doors open, which means the employees are going to carry the brunt of this. It's going to mean fewer wage increases, probably not reach the wage that they had hoped or receive the wage that they had hoped. It's just going to hold us back. And then we're going to see businesses that have the option, and we hear this all the time, that if they don't have to operate out of a location here in Minnesota, it gives them one more incentive to move across state borders. And we don't want to see that. From where I'm at, we see taillights heading west quite frequently, and we need to stop that. We want to keep the people here, the workers, we want to keep the businesses here. We're stronger together, and this is not helping us do that, which for a lot of reasons just continues to repeat the theme of send this back. It needs to be reworked. We've got to correct some of these things. We hear about the school districts. Our school districts are running real scared of this. Our cities, our counties. In most cases, they've got provisions built in to their employment benefit package already. My local school district made that comment already. They already do this in their own way, and their own way works for them. They don't need this, don't want it. It's going to cost them more money, which means our taxpayers are going to pay higher property taxes. And I'm sure there's going to be plenty of employees that'll say, and again, we've heard $3.50 a week, whatever those numbers work out with their particular payroll. But no matter how small or how big that is, they don't want this taken out. They would rather have that in their paycheck each week. They get to decide how they're going to spend it. The private plans would not be a failure. We do not need to be afraid of that. That is the system that would make us stronger as a whole. We need to allow business owners, business managers that make these decisions, we need to empower them. They are the ones that keep people busy every day. They're the ones that make our economy roll. And this just hand ties them and just makes them throw, in some cases, throw their hands up and say, we're going to leave. And we just absolutely do not want that. Mr. President, I do see I had one more question I had missed earlier, so if Senator McQuaid could
she will yield
for
Senator
another.
Uckey.
Thank you, Mr. President. Thank you, Senator McQuaid. And that question, as I looked through the bill quickly, I didn't find. How does this affect family members? If I am employing family members and paying them through my payroll, are they included or can they be exempted?
Senator McQuaid.
Thank you, Mr. President. And to Senator Uckey's question, there were a lot of things that he said between the last question and this question that I think are really important. He talked about the incentive to move across state lines and wanting to keep workers here. 61% of people ages 45 and under surveyed said that paid family medical leave was the most important issue. And why? Because if you get in a snowmobiling accident, diagnosed with cancer, have a baby, or your baby ends up in the ICU, you have an emergency appendectomy or a cholecystectomy, and you have to take time off of work and you don't get your wages replaced, you could live in poverty, lose your home, not be able to feed your kids or pay your bills. Minnesotans understand this. This is how we attract and retain workers, which we have seen in other states. 80 to 90% of the businesses surveyed in states where they have paid family medical leave love or are neutral on the program. It has increased employee retention. It has helped small businesses compete with large businesses. The private plans that we keep hearing about happened in Virginia. The state legislature authorized the State Corporations Commission Bureau of Insurance to approve the sale of private family leave insurance products. And as of February of this year, only one insurer has applied to offer a family leave insurance product, and no employer has purchased it. This was also done in New Hampshire. After an open enrollment period, 149 employers signed up. That's 149 out of 44,509. So that's 0.03% of employers. So said a different way, 99.7% of employers did not sign up because the program does not work. It is a literal failure. It's not a guess. It's exactly what has happened. Look, we don't have to guess about what will happen after this bill is passed into law. And we don't have to guess about what would happen if we did the private plans. But to the question about family members, employees, whether you're related to them or not, married to them or not, are treated the same under this plan. Employers and employees both pay in, and everybody benefits.
Senator Uckey.
Thank you, Mr. President. Thank you, Senator Mayquade. One final comment as I wrap up. We hear about, and we've heard this repeated a number of times today, the percentages, if they've polled this, how many people want this. But what we have to remember, the employees don't make the decision of where these businesses are located, and if they decide to move across the borders to another state, that is the owners. They need to be included in this conversation. A lot of them do offer various forms of this package because they know what it takes. Because as I mentioned earlier, we all need employees when we have businesses. They are the most valuable asset we've got, and we're going to do everything we can to take care of them. But the owners make the decision, and that's where we're going to see problems. So with that, members, please vote to send this back. It does have significant concerns and shortcomings, and we can make this better. Thank you, Mr. President.
The good senator from Rochester, Senator Nelson.
Thank you, Mr. President. Well, I stand in support of the motion to reject this conference committee report. And I want to speak to why I think it is premature at this point with the information we have, or shall I say the information that we don't have today, to move forward with this conference committee report. This is premature, members, because, as you have heard, we do not have an actuarially sound product. And I just want to make sure that everyone is very clear that in the state of Minnesota, before an insurance product can be offered to our citizens, there are some general aspects that must be true. I'm only going to tell you at this moment about the third one of those. It is called actuarial soundness. Insurance policies are typically required to be actuarially sound. Actuarially soundness means that the premiums charged for the policy are sufficient to cover the anticipated claims and expenses. And of course, this helps ensure the long-term financial stability, and it prevents excessive or inadequate pricing. Now, my concern is exactly what we have heard here on the floor, that is the pricing, is the employer and employee employment tax, the new insurance tax, is that going to be sufficient to pay for the promises? Well, clearly, the promises keep changing between different committee stops. The premiums or the allowed, and we call them premiums, but these premiums are employment taxes paid for both by the employee and the employer. Those taxes keep going up or down, but there is no corresponding movement with the promises. So this clearly is not actuarially sound, members. It is premature, it is irresponsible for us to think that we would be doing anyone in Minnesota a favor and helping them out if we put forth a product that is not actuarially sound. What we have here is really a recipe for maybe feeling good that we think we're providing paid family leave. But what good is that if the promises are not met? It'd be better to not make those promises than to have Minnesotans count on the promises of a paid family leave plan that are not going to be met. And to add salt to the wound, this legislation would be forcing Minnesotans to give up the paid family leave that they have either already negotiated with their employer or their union has negotiated, that has been tailor-made for what those employees need and want. So I will save my comments about the financial irresponsibility of this plan should we get to the conference committee report. I hope it is not today, members. Today is the day where we need to send this bill back. The effective date would allow us to send this bill back until we get the actuarial study, which I believe will be in October. How can we pass a bill without being actuarially sound? We are not doing right by constituents. We're not doing right by our taxpayers. And that, my friends, is the rest of the story. You've heard Paul Harvey. We've heard stories talked about on the floor here. But if we are not able to keep our promises, we are doing more harm than good. We must reject this conference committee report at this time today, get the actuarial study, and then come back and provide real paid family leave that Minnesotans want, deserve, and that they can count on. I encourage a yes vote on this reject motion.
To the good senator from Rockville, Senator Howell.
Well,
and
thank you,
Senator Duckworth, I already have you on the list. Senator Howell.
Thank you, Mr. President. I greatly appreciate that. Members, everyone here wants to see a paid family leave process. But there's a large difference of opinion on how that should be done. But, Mr. President, would the senator from Apple Valley yield for a question?
The senator from Apple Valley, better known as Senator McQuaid, will yield. Senator Howell.
Thank you, Mr. President. And Senator, and Mr. President, I'm looking at page 13, line 1322 of the conference report, and it talks about a calendar day. And the definition here is it's a fixed 24-hour period corresponding to a single calendar date. My question is how does that definition then, and how does that actually fit into the calculation of the wage benefit that the employee is looking at receiving?
Senator McQuaid, to the question, and you can take a little time if you need to find the answer. Senator McQuaid.
Thank you, Mr. President. I am taking time, and the time is telling me that I still don't understand the question.
Senator Howell, to the question.
Thank you, Mr. President. And the question I have is we're defining a day here specifically to a single calendar date. Many of us in the past did not work their work shifts in a single calendar date. We worked them, some of us as firefighters, worked from an 8-hour day in the morning till midnight, and then worked in another calendar day from midnight to 8 a.m. So we worked a 24-hour shift, but we worked it in 2 calendar days. So my concern here is, and I was actually involved in a lawsuit regarding the definition of a day. It took 4 years, members, to figure that definition of a day out. So I think it's important for us to determine what this day means to the benefit to the employee. Because if the employee is banking on how this is going to pay them and how this is going to work, they need to know how the definition of the day applies to the calculation. So some folks work a 24-hour shift like I used to, 16 hours in one calendar day and 8 hours in another calendar day. Some people work swing shifts where they have 2 or 4 hours in one calendar day and 6 or 4 hours in another calendar day. So members, it's important for us to define that and figure out how that's going to affect the end result in the employee's wages. That's the question, Mr. President.
Senator McQuaid to the question.
Thank you, Mr. President, and thank you, Senator Howe. I understand where you're going with it. I think what's important to know is that benefit formulas on wage replacement are based on the average over a quarter. So where you're seeing the definition of calendar day here on 13.22, if you look throughout the bill, you'll see calendar day referenced. For example, a qualifying event has to be 7 calendar days. I think that is probably or you have to be absent from work from 7 calendar days. So the calendar day definition that you see here is being used throughout statute to define different periods, but the wage benefit period is calculated on the back end with an average over quarters. And so what you're talking about with a shift being on 2 days isn't relevant to how we're defining and using calendar day in this bill.
Senator Howe.
Thank you for that good answer, and thank you, Mr. President. Would the senator from Apple Valley continue to yield?
Will you yield? She will yield. Senator Howe.
Thank you, Mr. President. And that goes into, so that's good to know. The employee is going to know that their wages are based on the quarter. But then on page 19, lines starting at line 19.4, it describes, actually you could go down to 19.10, a period of incapacitation of 7 days or more, and any subsequent treatment or period of incapacitation relating to the same condition. How are those days calculated?
Senator McQuaid.
Thank you, Mr. President. The answer to the question is that those are calculated by 7 calendar days, which would be a fixed 24-hour period corresponding to a single calendar date.
Senator Howe.
Thank you, Mr. President, and thank you for that answer, Senator. So the concern I have is taking a firefighter, for instance. They now are going to hit, because there's many different firefighter schedules out there, but they schedule, let's say they're scheduled for a Monday, Wednesday, Friday. So they would have all of that week, it would work for them. But let's say they end up with an injury on Thursday of that week. And let's say so that would be the after midnight section. So it'd be from 12 midnight to 8 a.m. They end up with an injury or a health condition, and that would go into their Friday and into their Saturday, but now they have 4 days off. How does that work for the calculation?
Senator McQuaid.
Mr. President, what is he asking me to yield?
He did ask you to yield, or he is asking you to yield. Senator McQuaid.
Thank you, Mr. President. And the answer to the question is, so this would apply to future shifts, I believe. I'm not totally clear on the question. I'm gonna follow along on this, and maybe through this answer, this will be helpful to Senator Howe. So let's say I'm a firefighter, and I'm scheduled for a shift on Thursday, and on Wednesday, I have an emergency appendectomy. I will be incapacitated and unable to perform my job for more than 7 days, but certainly for 7 days. And so I will have a doctor certify that I have a qualifying medical condition that qualifies me for leave. I will notify my employer as soon as practicable, so hopefully before I go into surgery, maybe right after I wake up from surgery, and then that application will go to the state, and then they will calculate my average earnings and wage replace for the duration that I am out. And so it's not related to shifts in the way that you're thinking of it. It's related to the length of leave that people have, and the amount of leave that they have when they're working out their schedule with their employer would just be based on how their schedule was scheduled for the amount of time they need to be out if it was an emergency like that.
Senator Howe.
Thank you, Mr. President, and thank you for that answer. I think there's a little bit of concern there for me, because I don't think that's been well thought out. Like I say, it took me 4 years of being in court to figure that definition out, because most times it's defined by how they pay you. So how they pay you defines your workday. But with that, members, I will say it's one of the reasons I don't think this bill is ready. I think we need to go back to conference committee. I think it's been mentioned here. It's not actuarially sound. They haven't done that. There's a 70% variance on what that premium is going to be. So the employee really doesn't know how much this is going to cost them. And we've heard from members here today that, well, it's not costing very much. It's only $7 a week. Well, members, $7 a week is $100 more than the governor is going to give back to the members of the $19 billion surplus. So I guess that's even less than not very much. Members, the Senate position was 1% for the fee cap. It came back from conference committee at 1.2. We needed more of a variance because we don't know what this cost is going to be. The employee notice, it's going to be done in 5 languages, but they did not allow the employers to add additional languages and request additional languages. And that's similar language that was actually included in the safe and sick time bill, but it's not included here. Another reason to send it back. The Senate position was that the commissioner, if they started to have premium issues and they didn't have enough money, could come back to the legislature with options to address the shortage. That's not what the conference committee report says. The conference committee report gave the authority from the legislature to the commissioner just to determine what it is and raise the fees. So members, the concern here is the employee really has no idea what this is going to cost them out of their wages. They have no idea how this is going to affect their paycheck. So members, that's the reason this needs to go back to the conference committee. Let's get this thing right. Let's put some knowledge for the employees so they actually know the cost and how this is going to affect their back pocket, so they can ensure that they can continue to pay their mortgage, pay their rent, keep their lights on. That's what we need to do. Let's do the responsible thing and send this back to conference committee. Let's accept the Draheim motion to reject the report. Thank you, Mr. President.
To the good senator from St. Michael's, Senator Lucero.
Thank you, Mr. President. And I appreciate the conversation that we've been having this afternoon on this important topic, because I am also one who strongly believes in people trying to maximize opportunity for people, and that's best done when people are empowered with choice. But one of the things that I'm concerned about is that this bill actually does the opposite of that. As I have explained in previous conversations on earlier versions of this bill and other bills, that people are different. People have different needs. They have different circumstances in their life. They may have children. They may not have children. They may be married. They may not be married. They may have health conditions. They might be perfectly healthy. Every one of us is different. And as such, we are empowered as individuals when we're seeking employment, when we're looking to establish an employee-employer relationship, to prioritize those needs that best fit our circumstances. I can recall when I was younger, as I had mentioned, the raw salary was the most important variable for me when I was younger. Why is that? Because health, which is what this bill seeks to take into consideration, health was not as high a priority for me. And for many young people, it is not. Because younger people are generally in a healthier condition. Young people want to start their lives. They want to start their families. They want to get an automobile, maybe multiple automobiles, recreational vehicles. They might want to get that first home. They might want to expand and get a move-up home. And in order to accomplish that, they need to maximize the income portion of the equation. Now, Mr. President, why am I referencing these items? Well, it's because from the employer standpoint, employers have to take into consideration the totality of the circumstances. And in this case, it's the totality of the costs. One of them is simply the salary, but that doesn't end there. There's unemployment insurance. There are other benefits, health insurance, the employer portion of the health insurance potential benefit. There are, in fact, there's even pet insurance out there now. And an employer can offer that, and that's part of the equation, if an employer or an employee agree to that. And so the employer, these and other costs, there's the FICA tax, which it's also commonly known as the self-employment tax sometimes, and if its person is independently employed, self-employed. But that tax is the Social Security tax. Now, I know we've had a lot of conversation this session on Social Security tax, but that's not what I'm referring to in this particular instance. It's not the tax on the Social Security income. It's actually the tax that goes into the Social Security Ponzi scheme, the federal Ponzi scheme. And there's an employee-employer half to that equation. And so when we're looking at this bill, and as I've been considering the Draheim motion to reject this conference committee report and send it back to conference committee, I very much appreciate these words, and some of these have been brought up. But one of them is the cost of the employer. Now these conversations, and I very much appreciate all the voices that I've been hearing today, Mr. President, on this. It's not just the employer, it is also the employee, and that's why I opened up my remarks with empowering employees, individuals, with opportunities that fit their individual unique circumstances. But this bill before us is a one-size-fits-all. It tries to prescribe that everybody fits into a particular box, and that box is best suited for everybody, whether they're at the younger end of the age spectrum, or they're on the other end, the more seasoned end of the age spectrum. And again, this is something that it's going to deny those, regardless of the spectrum that they're on, the ability to choose, hey, employer, I would like to enter into a voluntary agreement, a voluntary relationship with you. And in return for my labor, I'm looking for compensation. Now, that compensation, I understand that there are several options out there to compensate me for my time. But based on those circumstances, I'll just throw out a hypothetical. Based on those circumstances, I need to maximize the income. And I have alternative sources that I might be able to, if I can maximize, employer, the income you pay me, I can set aside money into savings in a scenario, and I don't want you to spend the money that you otherwise might have been spending on these one-size-fits-all government mandates, and I want you to just put that into the salary or the wages and then pay that to me directly. That's why I have very big concerns with this bill. It's the one-size-fits-all, and there are a number of concerns, unintended consequences that are absolutely going to happen, and I'm going to enumerate some of those in my remarks right now. But I'm going to begin with, Mr. President, and honestly, I've heard several authors yield for a question, so I honestly don't know who the chief author is. I've heard Senator McQuaid, I've heard Senator Mitchell, so I'll start with Senator McQuaid if she would yield for a question. And I don't know if she's the best one to answer. Mr. President, if Senator McQuaid would yield for a question.
Senator McQuaid will yield. Senator Lucero.
Thank you, Mr. President, and thank you, Senator McQuaid. Senator McQuaid, I'm looking at page 2, and the first thing that I looked at here when I was reading through the bill is beginning on line 2.5. It speaks about data classified under this paragraph may be exchanged, and then it reads, between the department and the Department of Labor of Industry and the Department of Commerce. So the Department of Labor and Industry and the Department of Commerce are specifically enumerated, but the department is not at the end of line 2.5. And when I flick back, many times when you flip back, there's a reference early on in bill language that says the department, and then it'll spell out which executive agency that is. I just didn't see that here, and I may have missed it. So I'm wondering, Mr. President and Senator McQuaid, who is this third department that's referenced there on line 2.5?
Senator McQuaid.
Thank you, Mr. President. To the good senator from St. Michael, Deed.
Senator Lucero.
Thank you, Mr. President. Okay, and thank you, Senator McQuaid. By the way, just as an aside, Mr. President, in the other body, they say the member from right or the county. They don't reference actual city, it's the county. But I know we want to be different here in the Senate, so if we were trying to...
Just so you know, the Senate tradition was to do the same thing from the county, but we are the Senate, so we have things that we like to do our way. With that being said, Senator Lucero.
Absolutely. Thank you, Mr. President. And I appreciate the helpful answer on that, Senator McQuaid. So there will be 3 departments by which data can be transferred between. The next thing as I continue to flip through, I'm on page 14, and so I would just ask or reference Senator McQuaid and others to that page. And Mr. President, if Senator McQuaid would yield for another question.
Senator McQuaid will yield. Senator Lucero.
Thank you, Mr. President, and thank you, Senator McQuaid. On this page, on page 14, it has several definitions in there. One of them is covered employment. Then down below on line 14.24, it references employee. And then on line 14.29, it references employer. And so with this page of covered employment, employee, employer, I was looking through the definitions, trying to decipher or untangle just several scenarios that are very real here, especially in Minnesota with our neighboring, I'm just going to use Wisconsin in a set of hypotheticals here. Would the scenario be, so in the scenario of a Wisconsin resident employed by a Minnesota employer, Wisconsin employee, or a resident, Minnesota employer, will the employer, or it depends how you ask the question, would the employee, the Wisconsin resident employee, qualify to submit applications for benefits under this program?
Senator McQuaid.
Thank you, Mr. President, and to the good senator from St. Michael. Actually, on 14.22, that answers your question about department. So the answer to your question, the employers are the employer of choice here.
Senator Lucero.
Thank you, Mr. President. And thank you, Senator McQuaid. I do see on line 14.22 the answer to the department question, so I appreciate you drawing that to my attention. If she would yield for another question.
She will yield.
Thank you, Mr. President, and thank you, Senator McQuaid. Could you expand the, how did you phrase it? You said employer of choice, is that what you said?
Senator McQuaid, to the question.
Thank you, Mr. President. So if the work is performed in Minnesota, they are subject to the premiums.
Senator Lucero.
Thank you, Mr. President. Okay, and that gets to, and I have a number of scenarios here. So if the work is performed in Minnesota, so how about the other scenario then? It's if she would yield for another question, Mr. President.
She will yield. Senator Lucero.
Thank you, Mr. President, and thank you, Senator McQuaid. So obviously, as you're well aware, there are many different types of industries with many different types of employee types of work that exist out there in the universe of work. And many of those where the employee is performing work outside of the state of Minnesota where they might be employed by a Minnesota company. So in the scenario that this Wisconsin resident is employed by a Minnesota employer, but their job duties are actually outside, they're actually being performed outside of Minnesota, would that Wisconsin resident qualify then to submit applications for benefits in this program when their job, their function is outside of the state of Minnesota?
Senator McQuaid, to the question.
Thank you, Mr. President. And to answer the question, so this is actually articulated quite clearly in 14.9 down to 14.17. 50% or more of the employment during the calendar year is performed in Minnesota. 50% or more of the employment during the calendar year is not performed in Minnesota, but some of the employment is performed in Minnesota, and the employee's residence is in Minnesota during 50% or more of the year. Or 50% or more of the employment during the calendar year is not performed in Minnesota or any other state, but the place from where the employee's employment is controlled and directed is based in Minnesota.
Senator Lucero.
Thank you, Mr. President, and thank you, Senator McQuaid. Well, I appreciate that you use the words that this is very clear, but I don't think it is very clear because your earlier words in an earlier answer were not the employment. You said that the work performed. So when I think of the employment and the work performed, those are two very different things. Because the employment, as you're reading here, like you referenced 14.9, 50% or more of the employment. I interpret that to mean that there's an employee-employer relationship with a Minnesota-based employer. That's employment. But that's not the job, that's not the function. Per your own words, you said if the work is performed in Minnesota. But my question is, if the work is outside of Minnesota, and let me just give an example. So in the area of sales, it's very common of traveling salespeople. But and I'll just use what I'm familiar with, the area of cybersecurity or technology. There are many salespeople that are selling different components, software, hardware, et cetera, that they're traveling. They have a regional territory. And so the employer might be based in Minnesota, but the salesperson is actually doing sales and their functions for 9 months out of the year in another state. And so the employment is in Minnesota, but the work is outside Minnesota. So, Mr. President, if Senator McQuaid would yield for question.
Senator McQuaid, she will yield. Senator Lucero.
Thank you, Mr. President. And so that's what I'm trying to get at here. And I think the words that you're using are highlighting that this is not very clear. So I beg to differ that this is not clear when you read this. So can you help clarify your usage of the word the work performed versus your second answer, which highlighted employment? Can you highlight those differences?
Senator McQuaid to the question.
Thank you, Mr. President. And Senator Lucero, I was answering the specific case you gave in the first example. So it was the work being performed by that person who lives in Wisconsin but works in Minnesota. Yes, they'd be subject because they work in Minnesota, which is Clause 1 of this bill, of Subdivision 15 in Article 1, Section 9. If you want to continue on into the person who does sales and they do it outside of the state, now you're going into Clause 2 or 3. So, if 50% or more of employment during the calendar year is employed in Minnesota, yes, they are subject to it. If 50% or more of the employment during the calendar year is not performed in Minnesota, but some of it is employed in Minnesota and the employee lives in Minnesota for 50% or more of the year, then it applies. Or if 50% or more of the employment during the calendar year is not performed in Minnesota, but the place from where the employee's employment is controlled and directed is in Minnesota, it applies. So my answer to your first question was based on your first question. My answer to your second question is based on your second question. My answer to all of your questions would be 1, 2, or 3, depending on the different scenarios you give me.
Senator Lucero.
Fantastic. Thank you, Mr. President, and thank you, Senator McQuaid. So as you're answering that, then, you said, the verbiage that you just gave is if it's controlled, I think under number 3 here, I don't have it highlighted, so if the place where the employee's employment is controlled. Okay, so that controlled and directed. So what does that mean? Let me give another scenario. So in my capacity as a consultant, I have worked for a number of employers, and one of the employers that I worked for had multiple locations throughout Minnesota. I may have been a resident here, so that would certainly qualify for the 50% threshold, because my residency is 50% more of the year. But my direct boss that I reported to was in another one of the locations in the United States, and the employer didn't have anything here. So the question is, how is my work being performed? So if I'm a resident of Minnesota, I might hit that 50% threshold. But how about a scenario where I'm not in Minnesota, hitting that 50% threshold? But there may be an office here in Minnesota. There might be an office. But my direct report is a resident of another state, Virginia, for example. If my boss is a resident of Virginia and directs my time directs my work and controls, where is that coming from? Is it coming from Virginia? Is it coming from the Minnesota office? I think there's an area here where it's not very clear when reading this language in. Employment is controlled and directed, because the controlling and the direction of my employment would be from a different state. Even though there might be an office here, if I'm work from home and not going into that office, the office in Minnesota may not be relevant whatsoever. But then again, if I'm not here, if I'm here for 49% of the year, is that a loophole? Is that an intended loophole or not? Something for us to consider as we are exploring and pondering the Draheim motion to reject this conference report and send it back to committee. As I'm flipping forward in the bill here, I'm now on page 33. On page 33 of the bill, I'm on line 29 that says, and this is under the section of the notice to the employer. Notice to the employer. On line 29, it says the employee shall provide at least an oral, a telephone, or a text message notice. Now, Mr. President and members, the first thing that comes to my mind is technology failure. There have been times when a voicemail has been left and somebody calls me up a week later or gets a hold of me somehow a week later and says, Eric, you know what? Why haven't you responded to me? Why haven't you acknowledged me? Do you not care about me anymore? Are you mad at me for some reason? And in these scenarios, I have said, I honestly have no idea what you're talking about. And I'm sure each and every one of us, Mr. President, has experienced circumstances where somebody may have left us a voicemail and we didn't get that indicator on our cell phone. We didn't know. I then actually did, and I'm sure we've done this before, we've done the manual dialing in. If you call your own phone number from your mobile phone, you will get to, it'll go to your voicemail box, of which you can enter in your PIN and get your voicemails. And I've done that in this circumstance, and I was actually shocked that there was a voicemail there. Never got the indicator. That's a technology failure. Same thing has happened with text messages. But oral, when I see oral, I'm concerned about liability. I'm concerned about liability. So what happens if this is not received? What happens in the scenario that there is a shift that an employee is scheduled for? The employer is counting on that employee to show up for their shift. The employee left a voicemail. I think you can leave it up to 60 days in advance. As early as practical, I think is the verbiage I had seen. So it could be 30, it could be 60. But in either of those scenarios, if somebody leaves a voicemail and it's never received, well, what happens? And that employee, that day comes, the employee left a voicemail, they thought that they had been acting in good faith, and indeed they had been. But that day comes, the employee is absent, the employer never received notification. Now what? That could create, depending on the industry, depending on what other items or actions might be happening, it's going to catch that employer or that manager on duty off guard. And what happens when a manager is caught off guard? What happens when a shift goes unfilled? Well, one of two things. In the case of an assembly line, they might have to call somebody else up because they haven't had the time to prepare. And now the employer, because they have not had the time to prepare, because they didn't get the voicemail from 30 days ago, they're going to have to pay overtime and potentially double time and maybe even double time and a half. You know, when I was a truck driver, I actually enjoyed working the holidays because we were working 60-hour weeks as a truck driver, and I would jump on every holiday as I could because on holidays, so I was already double time and a half, and then you got that extra 8-hour holiday pay. So if you worked on the holiday, I was getting double time and a half. And so the employer might have to call somebody up to fill that shift that went unfilled, unexpected absence, and have to pay double time and a half. Now, that increased salary or wage that has to be paid is going to have to go somewhere. That increased expense is going to have to be embedded into the product or service. But what if the employer can't find somebody to fill the shift? Well, then what? Do they have to shut down the assembly line? I know that there are many industries with many safeguards, quality control, depending on the product that's being produced. That quality control is incredibly important, and in the absence of any particular employee, it might create danger in the product that's being produced because the specifications have little to zero margin for error. I'm very concerned about that. So I don't see any recourse in here. Well, what happens? What happens? But then what if that scenario happens and the employee asserts that they did leave notification. But what if that voicemail actually never is received for whatever reason? Can the employer then discipline the employee? Should they? I don't know. I don't know what the scenario is, but I think there are variables here that should cause us concern. And that's why I'm highlighting this as a reason why we need to support the Draheim motion. But when I think gray area, I know, Mr. President, that lawyers, they thrive in gray areas. They count on, in fact, we've even heard remarks on this floor on other legislation in the past, let's leave that up to the courts to figure it out. Well, I don't want to have the courts figure it out. I don't want to have gray area. That's why we need to support the Draheim motion. But again, when I think lawyers, I know that like 75% of the majority party in this body are lawyers or something to that effect. But we do have at least one lawyer on our side. The great senator from the great city of Blaine or Spring Lake Park. I'm not sure which one. Probably Blaine. So, Mr. President, I'm wondering if Senator Kroon would yield for a question.
Senator Kroon, you mean the one that's sitting right next to you that you couldn't ask a question of other than now? Senator Kroon.
Would he yield, Mr. President?
I believe he said he would yield. He even gave me the thumbs up.
Perfect.
Senator Lucero.
Thank you, Mr. President. I appreciate it. In my full adherence to the custom and usage of this body, I didn't turn my head even the slightest angle to see what his action was.
Thank you so much, Senator Lucero. Senator Lucero.
So thank you, Mr. President. Thank you, Senator Kroon. And I know that you had spoken earlier on another topic, and I'm going to ask you on that. But on this area, do you see this putting on your lawyer hat? And I'm not going to put I'm not going to ask you, I'm not going to frame the question in a manner by which you would be on the plaintiff or defendant. But I want to ask you, just in your opinion, when you see language like this, oral, telephone, or text message is sufficient. When I see the word sufficient, again, it's vague. When you read this, in your experience as a lawyer and a contract lawyer, is such terms, would this be satisfactory? Is this satisfactory language for these purposes, which could have huge impacts to both the employee and employer, or should this be more clarified by supporting the Draheim motion? And by the way, Mr. President, in case you may not have been listening, I'm looking at line 33.29, the words oral, telephone, and text message.
Senator Kroon, he's going to give us legal advice. Senator Kroon.
Thank you, Mr. President, and Senator Lucero. Notification requirements under law vary pretty widely depending on the circumstances, the law that we're talking about, what the intent is for. There's all sorts of notice requirements within the law, the legal process itself, in terms of providing notice of a lawsuit, service of process can vary in and of itself. Usually that is done through personal service by a process server handing a summons and complaint to an individual to effectuate service. Now that's obviously the most formal mode of service that we have, that is to commence a lawsuit. And there's various degrees of notice that fall short of that, less formal, if you will. And it can always go down to kind of the legal proposition that service by mail between attorneys after a lawsuit is started is deemed sufficient upon mailing. So it kind of really depends on what the context is. In this, we're talking about, I believe you're on page 33, notice from employees to employers to notify them that the need for leave, and we're talking about oral, telephone, or text message. And I think your question is, could it go back to the conference committee for some clarification? Sure, yeah, it absolutely could. You could write some details in there. There's always the possibility that an employee could think that they've satisfied this requirement by sending a text message that wasn't actually received by the employer. That is a possibility, and there are ways to address that, to button that up, I suppose. But fundamentally, notice can take anywhere from very formal to pretty informal under the law, and it's anywhere in between. So I don't know if that answers your question, but that's my take on it.
And just a friendly reminder, Senator Kroon, when you're speaking, if you can bring your mic just a tad bit closer, because I was struggling to try to hear you. Thank you so much. Senator Lucero.
Thank you, Mr. President, and thank you for that, Senator Kroon. I do appreciate that. And as you were explaining that, Mr. President, Senator Kroon, actually another scenario came up, a real-life scenario, and I'm sure each and every one of us has experienced this. Either we have been one who has attempted to send an email, and then we ask the recipient a couple days later, well, have you got it? And come to find out that it's actually in our outbox. For whatever reason, it wasn't sent, attachment too large, whatever. And I know the same thing is we've probably been recipient. I've been waiting for your email, but we haven't received it and it's stuck in the outbox. I'm providing these real life examples because when it comes to text message, the same thing has occurred. I'm sure those of us have been in the middle of trying to send a text message. Maybe we got distracted. Maybe something happened at that point. There was a blip in the cellular connectivity network, whatever might have happened. And the text message actually wasn't sent, but it was saved as a draft in our text message thread. And so the message may not actually have ever been sent, let alone be received. And that's where this is something that, again, I'm concerned about. But, Mr. President, if Senator Kroon would yield for one more question.
Senator Kroon, he will yield for another question. Senator Lucero.
Thank you, Mr. President, and thank you, Senator Kroon. So on the topic of employee or employer, you had earlier referenced when you were speaking federal preemption. Now, I'm not a lawyer, as you know. I've heard this term several times throughout the conversations on this bill. I believe that it's either referenced or at a minimum you referenced it in your early remarks. Can you just provide some background clarity on exactly from a legal standpoint? Is that a constitutional thing? Is that a federal statute related thing? Can you just provide some insight then on how the federal preemption relates to this bill?
Senator Kroon.
Thank you, Mr. President. Thank you, Senator Lucero. My comments with respect to federal preemption have to do with, in this case, my specific question was about the railroad industry, and it stems from kind of the supremacy clause. If the federal government, through Congress, establishes something specific regarding interstate commerce, then that would be supreme over subsequent state laws. And that's kind of what we're talking about here with the railroads. There's a federal statute called the Railroad Unemployment Insurance Act. And what that federal statute does is has an exclusive provision for the payment of sickness benefits for sickness periods for railroad employees. So, you know, and it has preemption language right in the statute that says no employee shall have or assert any right to sickness benefits under a sickness law of any state with respect to sickness periods occurring after June 30th, 1947. So this is a very, very old federal statute. It's very commonly understood that Congress, in its wisdom at the time back in the 1940s, wanted to regulate the interstate commerce of railroads, and it decided that it was going, on a federal level, going to establish certain benefits to those railroad employees. And so the states subsequent to that have dabbled in this kind of paid family leave area have specifically called out that exemption and exempted those railroad employees from those state acts. and there has been some litigation over that in the courts where a state does assert that federal preemption hasn't occurred or only partially occurs. In those instances where litigation has ensued, the courts have unanimously held that sick benefits are exclusively federal preempted under the exclusive jurisdiction of the federal statutes. So I guess my point in bringing it up was simply, rather than get the state embroiled in a costly lawsuit where the taxpayers are footing the bill to defend the lawsuit, that this bill should include specific preemption language with respect to the Railroad Unemployment Insurance Act to avoid that litigation, to save the taxpayer dollars when there really isn't any doubt that federal preemption exists. That was my point in bringing it up, and really why I brought it up with respect to the Draheim motion here was because when it left the Senate floor, it had that specific language in it. And when it went to conference committee, they took the specific language out with respect to the railroads and just kind of made a broader, more general statement about federal preemption that really did nothing but restate what the law is. And so I was just hoping that we could send it back and get that specific language put in there, save the taxpayer some dollars and not having to defend any kind of litigation that might ensue.
Senator Lucero.
Thank you, Mr. President. I have a whole host of additional questions and comments that I will reserve at this time. I'm going to save those for after third reading. But for now, that's where I'll leave it. And I appreciate Mr. President and Senator Kroon in that supporting the motion before us right now, the question before us, the Draheim motion. And I would ask for a green vote. Thank you, Mr. President.
Senator Grutenhagen, the gentleman, or the great senator from Glencoe.
Well, thank you, Mr. President. Yeah, I rise in support of the Senator Draheim's amendment. And there is a couple questions I'd have for Senator May Quay if she would yield.
Senator May Quay will yield. She will not yield.
Oh, she will not yield. Okay.
She will not yield.
All right. Well, I'll at least inform the body of what my concerns is. You know, one of the things I noticed in this bill is that, the benefits that are going to be paid is based on this formula. It's 90% of wages that do not exceed 50% of the state weekly average. Then it goes on, 66% of the wages that do not exceed 50% of the state average weekly wage. Then it goes on, number 3, 55% of the wages that exceed 100% of the state average weekly wage. So members, the person who makes claims under this, let's say for a sickness, is only going to get a percentage of their weekly salary or as far as their benefit is concerned. So members, here's one of the concerns about this bill that I'd like to send back and have addressed. Inside this bill, on top of only having received 50% in many cases of their weekly benefit, they're going to have to pay state and federal tax on those benefits. So members, this is almost like a sick tax in a person in need. You know, one of the rationales for this bill is to help people in need. And yet here the government turns around, not only do they levy a tax on the employer and employee to provide the benefit, then they come back that when you use the benefit, they're going to take a minimum, according to the bill, they're going to take a minimum of 10% federal and 5% state if the employee requests it. And if they don't request it, then eventually the employee is going to have to pay it anyway. So members, this is almost like double dipping for the government, right? They tax them to provide the benefit, then when you get the benefit, they tax you again, even when you're in a situation of need. And that's what I call a sick tax. I mean, does that seem right? The least we should do is not apply state taxes to what their benefit is. So that's another reason this should go back if you really care about the employee and providing this particular benefit. Second thing is that I do appreciate one thing about the bill that I didn't see when it left the Senate floor. There is some provisions in the bill to address false or fraudulent claims. And it was a concern I brought up when I was on the Labor Committee, because we know human nature and we know a certain percentage of people will game the system for their own benefit. I wish that wasn't true, but if it wasn't true, we wouldn't need police, we wouldn't need jails, and we wouldn't need speed limits, because everybody would just naturally do the right thing, and that just doesn't happen. So I do appreciate those types of provisions in here. You know, Senator McQuaid wanted to yield for a question. If she changes her mind, let me know, okay? Mr. President?
I certainly will let you know. She is not going to yield. And perhaps it won't take you that long, Senator Gruenhagen, but we will wait. Senator
All right. Thank you. The other thing I'd like to address, there is an exemption, although it's a little bit complicated, for hospitality. And members, you can turn to page 18, but if you start reading the actual bill, the way it works, there's certain provisions. And one of the provisions, and again, turn to page 18, the employee meets or will meet the 150-day maximum employment duration under this subdivision. So they can't go over 150 days. The employer primary line of work is hospitality. The employer meets the receipt thresholds under this subdivision. The employer has provided the required employee notice required under Section 268B. Members, I can't think of a more complicated way to have to notify people and keep account of this than what we have in this bill. And I just don't see a lot of small employers working through this. The second thing is, on page 18, line 1820, it says, now listen to this, members. The employer must notify the department in a format and a manner prescribed by the commissioner within 5 days, members and Mr. President. He only has 5 days. And what does he have to notify? If a previously classified seasonal employee, based on the criteria I read before in hospitality, if all of a sudden that employee falls outside those parameters, which, by the way, the employer is going to have to keep track of, and like a restaurant, one of the restaurants my daughter works at, they've got about 30 to 35 part-time employees. Many of them having a full job, and then they work part-time as a waitress at this restaurant in order to provide some additional income, which unfortunately the state takes a nice percentage of. So here it goes. So the employer, he has to notify the commissioner within 5 business days if a previously classified seasonal employee no longer meets the criteria that I listed above and is no longer a seasonal employee. And the other thing that's confusing about this, members, is that it's not a January 1 to December 31st time frame that the employer has to worry about. It's any 50, if you read line 18.7, it's any consecutive 52-week period in hospitality. So he has to keep track of when he hires an employee from January to January, February to February on the other employee, March to March, and if any, I mean, ad nauseum. Just think he probably hires employees every month of the year. He's going to have to keep track of every employee for the 12-month period if any of them fall outside the parameters that I referenced earlier as far as hospitality. And we call this an exclusion? And this isn't going to drive the employer nuts? And it's also going to be very confusing to the employee who, by the way, if they draw any benefits, are going to have to pay state and federal taxes, which makes no sense at all. Then, continue on page, or on line 1812. So the employer must apply to the department in format and manner prescribed by the commissioner and certify that the employee meets or will meet the 150-day maximum employment duration under the subdivision. Members, think about a hospitality, which we know there's a large turnover in that particular industry. You hire people different times around the year, sometimes more when you're going to be busier, sometimes less when you're not as busy. And then every month of the year to keep track of every employee over every 52-week period of time. And then, honest to God, members, I mean, basically what we're going to have a lot of small employers become criminals, okay, under this provision. There's just no way to do this. The other question I'd have for Senator May-Quay, if she would yield, which she's not, is there some type of a computer program, at least, that the state will provide to small business owners so they can actually keep track of all this, or is it completely up to them? I don't see any provision to help them out other than this somewhat reimbursement that maybe they can use to keep track of all this. So members, this needs to be changed and simplified. You know, when it comes to government, there's a formula that should be used in almost every situation. It's called KISS. Keep it simple, stupid, okay? That's what should be used in every conference committee. Because when we look at these bills, and this isn't the only one, we're going to make as many people miserable as possible, both employee and employer. So members, this definitely, just this one provision needs to be straightened out. And then when you add to this that this exemption doesn't apply to ag, which, members, I have large farms insured through my agency. They use multiple part-time employees at different times of the year. Their situation fluctuates dramatically at times. You know, they're trying to run their farm, all the aspects of the farm, all the government, federal and state regulations, and then you're going to come to somebody who hires seasonal employees, more at sometimes a year, more at the other. Number one, they got to keep track of everyone they hire in the month that they hire them for the 52 weeks to see if they fall outside the, four parameters. I don't get it, members. I don't know who in the world comes up with this, but whoever it is should be terminated and go out and work in the private sector if they're working for government. The other thing, members, so farming is a big seasonal employer, and the farms are getting. There's many large ones that are going to fall within the parameters of these seasonal employees, which are not going to be eligible for any exemptions. Excuse me. So, the other thing I have a concern about, and the reason this should go back, I was chief negotiator in our school district for 6 years with certified staff. And so much of this is negotiated between an employer and employee. And members, when we negotiated, and by the way, we always settled without a strike, and we paid conference average or better while I was the chief negotiator. But the point is, the people at the table for certified staff, they decide where they want to put the money and how much. So what you're doing here, members, is they may want more benefits in a certain area and less benefits in terms of paid and sick leave. Well, you're taking that option away from them. Maybe they want, when they retire, to have their health insurance paid till they're 65. That's a negotiated item. Maybe they want other benefits that they and the people they represent consider more important than what this mandate does. So again, members, the more I read the bill, the more convoluted it becomes. And I don't know, obviously, if you have nothing else to do in life when you, other than to sit around and figure all this stuff out, I guess it's workable. But for the average people that work, and the employees and the employer, to understand this convoluted bill is only going to create a mess. And I think when businesses look to expand or locate in Minnesota, this is one of the things that's going to turn them away to a different state. I mean, members, look at your DFL bills that you're bringing forward. Even the Mayo Clinic says if you pass the nurses ratio, we're expanding someplace else. So many of the bills and the weight of those bills, including this one, on our employers who want to give good benefits, that want to provide for their employees. And members, I know this is a need, and we support paid and sick family leave, but this is the wrong solution. We need a private sector solution, and it does provide an option for that in this bill, but it's not explained very well on exactly how it would work. And I'm sure it's going to be a convoluted process for any private sector insurance plan to become eligible to meet the needs of the employees in this state. Members, please vote green and send this mess back before it hurts not only our employers, but especially our employees. And let's come up with a simplified approach that employers and employees can understand and can implement on a regular basis. Please vote green and support Senator Draheim's amendment. Thank you, members.
Thank you, members. Going to the good senator from Brook Park, Senator Eric.
Thank you, Mr. President, and that's why I always tell people I'm from Pine City, because everybody knows where Pine City is, and Brook Park is just my mailing address. I'm actually Pekegama Township. So, so anyway, Mr. President, I stand in favor of the motion to reject the conference committee report. Once again, it's kind of a recurring theme that I'm getting up to speak on these, and I believe that we just have not had the public input that's deserved on these bills. And I know this particular bill has been around the legislature for a number of years, but I want to compare it, Mr. President, to a bill that I carried for a number of years as well, the ECO Act. And, you know, we had a lot of folks who supported it and those who opposed it. And I worked for a number of years with people on both sides. And we made many, many revisions over a course of 4 years. And in the end, we had Democrats and we had Republicans in both chambers that supported the bill. And unfortunately, this conference committee report that's in front of us right now cannot say the same thing. It's not going to have support from members of both parties in both chambers. And it's been around a long time, Mr. President, but it has not gone through any significant changes that opponents of the bill over the years have brought forward as far as considerations that they've asked for. The adjustments have been fairly minor and not from all realms of the folks who have been opposed to it. And I think if we're going to get a piece of legislation as significant as this right, and as close to right as we can the first go-round, we have to be taking that consideration into the discussion as we move forward. And I just don't believe that's happened. And that's why we should be sending this bill back to conference committee so we can once again listen to some of that input. And it's coming from all over, Mr. President. You know, especially the group that I've been listening to this year as the lead of the education committee is our school districts. And the impact that they're looking at that this is going to have. And even though we've heard about the record amount of funding that we're giving to our schools, this piece right here eats up a big chunk of that new funding. But I want to also talk about, what we haven't considered, and that I believe the conference committee should consider when we send it back, is when we talk about the support that's out there in the public, and we hear, 70 to 80% of people support paid family leave. Well, I believe when you take a survey, you will get those results. But that's only if you're looking at it in a vacuum and only asking about, well, do you support paid family leave? What's being missed in that question is all of the other aspects that someone considers when they're looking at their wage and their benefits. And so we have to ask the question of, do you want paid family leave, and at what cost are you willing to have that? And so what I want to point out, Mr. President, that the conference committee should consider is one of the groups that got an exemption in this is a group that I belong to, and that's the union construction trades. And so we should ask ourselves, why have the union construction trades asked for that exemption, and why were they given that exemption? And why wouldn't other groups out there around Minnesota want to have that same consideration? And members, Mr. President, here is why the construction trades asked for that exemption. As a group, Mr. President, when we negotiate with our contractors, who I actually am one also, we work together to find out what is the total package that can be afforded by a contractor for that trade. When that agreement has been reached, the members of the union come together, and we then have a discussion of what are our priorities? How do we want to disperse those dollars that have been negotiated with the contractor? We consider things like, what's the wage going to be on the check? What are our health benefits going to be? What about our pension, vacation, money that's going to go towards education and training for our apprentices? These are all things that are considered that have to fit within that dollar amount that was negotiated with the contractor. And because we take that time and so many of our members get involved in that discussion, I believe we have a much better understanding than so many workers tend to have as to what that cost is that the contractor has, and then what we determine are our priorities and what benefits we want. And I look at over the years, Mr. President, this benefit has never come up as one of the top priorities for the construction trades. We value our pensions. We value our vacation. We value our health insurance. And we understand, Mr. President, and the reason we ask for the exemption is because we know that that dollar figure that's been negotiated with the contractors is the top dollar. And if this were to go into effect in state law and we were under that, we would have to come back and re-vote on how we disperse those dollars, because state law would now say, well, this percent of those dollars now must go to this, and you have to reevaluate what you voted on as a membership and how you allocated those dollars. And by doing this one-size-fits-all mandate across the state of Minnesota, we are not giving any other employees that same ability to look at what their priorities are. Again, if you just ask, do you want this benefit? Sure, I want that benefit. But where does it fit in line with everything else that I want? What's on my paycheck? What's in my pensions? What's in my health care? We have to consider that, and this piece of legislation is not taking that into account, and so we have not really heard that input from the general public and the employees as to what that's going to be. And so, Mr. President, you know, what I would say, because we still do not have that local impact note, our employees truly do not know what that cost is going to be. And we can say right now it's a 0.7% payroll tax, but we already have it in the bill that this could go up to 1.2 because we're not 100% sure it's right. The problem is, what if that number's not big enough? We as a legislature may come back if we hear, oh, that number's not big enough and we're going to pass an increase again. The issue is those employees will have no say yet then. We are making that determination, and they will be losing other things within their, it might be on their paycheck, what's on their per hour. It may be on their health care benefits. It may be money coming off their pension. But when we make that decision here, they're losing that ability to make that decision with their employees or with their collective bargaining unit. So, Mr. President, members, this plan itself should be sent back to conference committee. Get that local impact note. Make sure people understand just what the cost is, not only for a school district, for a city, for a county, but for each individual employee as well, so they can make an informed decision. Is this the plan they want? Or do they want to have flexibility like we had in the plan offered last year, that they could say, yeah, you know what, I want paid family leave, but what I'm willing to put towards that would be a 4-week benefit. Or maybe it'll be a 6-week benefit. But they would have that flexibility, they would have that availability to make sure the plan would be what they want that fits their priorities. That's what we have to consider, Mr. President, and that's what this bill does not consider, and that's what hasn't been considered as this has gone through the process. We should agree with the motion in front of us. We should send this back to conference committee and let the conference committee get that local impact note, get the feedback from people as to what the cost is. Is this the level that they want it to be at? And then we can make the decision if we should be voting for this or not. So members, support the motion. Let's send this back to conference committee.
The senator from Lakeville, Senator Duckworth.
Thank you, Mr. President. I appreciate it. I just have a couple of questions and a couple of comments I want to make in regard to the bill and why I think it might be wise to send it back for conference committee so it can be improved. First and foremost, very supportive of the idea and the concept of paid family leave. I've voted for it in the past, although I disagree in the way it may be being presented now. And I also want to thank the bill's former chief author, who I hope is doing well. I know she's done some work on this bill and taken into consideration some of the points that were raised through the committee. The first issue I want to highlight, Mr. President, is on page 14. I won't ask any questions about this section, but I want us to consider how it might play out in reality, especially as it pertains to Minnesota workers or employees and Minnesota employers. It talks about covered employment and says that covered employment means a few different things. One of the items it mentions is a covered employment means 50% or more of the employment during the calendar year is performed in Minnesota. So that could be maybe a remote worker. The second thing it says is 50% or more of employment during the calendar year is not performed in Minnesota or any other state, but some of the employment is performed in Minnesota and the employee's residence is in Minnesota during 50% or more of the calendar year. And so between 1 and 2, whether you're maybe a remote worker who works for a company outside of Minnesota, but you live here or your work's done here, or 50% or more of your employment is done outside the state, but your residence happens to be here, I wonder how that might impact many of our border towns and communities. And what I see it as, Mr. President, is a potential disincentive to hire Minnesota employees or workers. Just think about it. If you live near the border of Hudson, Wisconsin, or Fargo, or Superior, or any other places along the border of the state of Minnesota, what are we signaling to employers regarding some of the things they're going to have to take on if they were to hire somebody who lives in the great state of Minnesota? Now, I happen to be in a district where we don't really border any states here in Minnesota, but I do own a few businesses, and we have locations in places like Woodbury, Winona, Hudson, Stillwater, and other areas in the state which are along the border. And what I would hate for businesses to do is look at great quality, qualified people who reside in the state of Minnesota, but choose maybe not to employ them or rank them lower on the prospect of potentially employing them because they know if they do hire them, they're going to be subject to a whole host of stringent requirements that the state's going to impose upon them. And I think, whether it's our tax code, whether it's our employment laws, et cetera, one of the things that's incumbent upon us as a state of Minnesota and the legislature and the governor is to always make our state as attractive as possible when it comes to bringing your business here, when it comes to employing the great people of Minnesota. And I think this provision in the bill, upon close examination, will actually prove to be a disincentive to hiring the great workers and employees of the state of Minnesota. So I would encourage the conference committee to reconsider that. The third one says 50% or more of the employment during the calendar year is not performed in Minnesota or any other state or Canada, but the place from where the employee's employment is controlled and directed is based in Minnesota. What are we signaling to our places of business that either exist or are potentially being considered about being created when we tell them if you center or base your business in Minnesota, you're going to be subject to a whole host of complicated, complex, and potentially rigid and costly provisions. And if you were just to drive right across the border, whether it's Wisconsin, Iowa, the Dakotas, what have you, you're not going to have to deal with those restrictions. You and your employees will have maximum freedom and flexibility when it comes to these benefits. But if you move just across the border, that business moves just across the border, well, you better hire some folks that are going to be able to help you to work through the provisions in this bill because you're going to be subject to all of them, and so are your employees. So, Mr. President, I would say let's send it back to the conference committee so they can figure out a way not to disincentivize hiring the great people of Minnesota or having businesses be based in our great state. A couple other items I want to mention, Mr. President. If we look to page 24, and I would ask just a couple of questions of Senator May Quaid if she would yield.
Senator May Quaid, will you yield? Senator May Quaid will yield. Senator Duckworth.
Thank you, Mr. President, and thank you, Senator May Quaid. I greatly appreciate that. I'm looking at subdivision 3 on page 24, which talks about weekly benefit amount, maximum amount of benefits available per rated amount. And the question I have is the question I've been getting from a lot of constituents and people in general about this bill, the employees and the hardworking folks of Minnesota who are here to represent. And the question is, under this benefit program that the state would be mandating and folks would be subject to, will folks get 100% of their pay if they're on this program?
Senator May Quaid.
Thank you, Mr. President, and to the good senator from Lakeville. What a wonderful picture that was painted about what we will offer here in the state of Minnesota versus our border states. Minnesota will be a place where we not only fund your schools, feed your kids in schools, cover infertility services, make sure you have paid leave when you have your baby, fund our parks, lakes, air, clean water, fix our roads, support people with disabilities, have beautiful, gorgeous infrastructure and natural resources. But we're also a place where businesses don't have to choose between not paying people who are out on leave or funding an entire paycheck for somebody who's not there and hiring a replacement. In Minnesota, everyone pays in and everyone benefits. That is the most attractive things to employees, which employers need in order to run their businesses. So if folks want to drive right across the border to have the flexibility to choose between their cesarean healing or paying their rent, I think they're going to stay here where they can heal and have their wages replaced. What we're signaling to businesses is that we care about employees, that we care about all Minnesotans, that every single Minnesotan is worthy, no matter their walk of life, no matter their job, no matter how much they make, because I'll remind you, Mr. President, that only 24% of Minnesotans have paid leave. Only 24%. And we've heard a lot about businesses should be able to do, they're doing so many great things for their employees, and we're taking that away. They're so amazing and benevolent, and yet they're not going to want to hire Minnesotans because of $3 a paycheck on average to steal away bonding time from a parent or discriminate against a spouse of a military veteran who's deploying. I don't buy that. I don't think that's how people operate in this world. So the answer to a lot of these questions, but specifically this question from the good senator from Lakeville, is that the wage benefit replacement, or the wage replacement benefit, is modeled after the opposite of income tax. So if you think of the brackets, right, your first bracket is taxed at this much, and the next bracket you get taxed at this much, and so on and so forth. So for the wage replacement, no one's going to have 100% of their wages replaced unless their employer would like to top off partial wage replacement, which I'm sure there are some companies and organizations who will be doing that. So it's not a no. Plenty of people might get 100% wage replacement. Some people will get partial wage replacement. Either way, they're still getting paid for their leave. And I will add one last time, Mr. President, that this bill is not about employers. Every person already takes the leave that they need. That already happens. This doesn't create the need for leave. The question is, will people still have some of their wages to continue about the duties that they have in life when they take that leave? That's what the question is in this bill. So that is my answer to the good senator from Lakeville. That is going to be my answer on a lot of these things, is that we have to start centering the people, the 76% of Minnesotans, the 76% of Minnesotans who do not have paid leave. That is who we need to be talking about. Thank you, Mr. President.
Senator Duckworth.
Thank you, Mr. President, and many thanks to the good senator who resides just east of Lakeville. My question was about employees entirely. Actually, I prefaced my question by saying many of the questions I'm getting from employees and constituents about how this bill is going to impact them is whether or not they're going to get 100% of their pay. And the very clear answer we just got was no. I guess maybe it wasn't the clearest of answers, but what you heard to the people of Minnesota was no. You will not get 100% of your pay from the state of Minnesota under this program. And I think it's important that people need to understand that, because oftentimes how some of these programs or benefits are sold to people is, yeah, this is going to be great for you. In exchange for the lack of flexibility and options you would otherwise have, you're going to get your pay. When in reality, if you dig into the bill, you realize, well, wait a minute, under certain circumstances, I'm only going to get maybe 90% of my wages if they don't exceed 50% of the state's average weekly wage, or 66% or 55%. It might not be what people think if they're not getting the full story or all the additional context. And I think that's what we owe the employees and the people of Minnesota. And as regard to my earlier comments, I think we are mistaken. I think we are gravely mistaken if we think for a minute there aren't going to be some employees out there who don't get hired in the first place, either because they happen to reside in Minnesota or because the business that would be hiring them feels that they're going to be subjected to a program they don't necessarily want to have to participate in. That's their judgment call to make. I'm not saying that's right or wrong. Or we're going to see businesses choose to base themselves in bordering states so they don't have to be subject to the program. And here's the deal. It's not because they're heartless and they don't want to provide great benefits. It's because they want to fight for and maintain the flexibility and options regarding the benefits they already provide. They could very well choose to base themselves in a neighboring state because they want to take a stand for their employees and protect and provide them the flexible options that they already have, and ensure that their employees aren't going to be mandated to abide by a program that's not going to pay them 100% of their wages. I think that is what needs to be considered. Would the great senator from Apple Valley yield for another question?
She will yield. Senator Duckworth.
Thank you, Mr. President. I appreciate it, and thank you, Senator Mayquade. So what if, we're talking about employees here, what if the employer would have offered them a more preferred option, or what if the option that they would have otherwise gotten had this not been in place would have been preferred by the employee? Are they going to have to then otherwise abide by this program instead?
Senator May Quaid to the question.
Thank you, Mr. President. Well, I'm super excited to hear that my Republican colleagues are in support of full wage replacement. The only reason we compromised on partial wage replacement is because it was an ask from our Republican colleagues, because they thought if people got all of their wages replaced when they were out on paid leave, then they would be fraudulent or whatever. You know, pregnant people are always just waiting around to not work, that myth. So I am very excited to bring back the bill next year, probably with Senator Dr. Mann, for full wage replacement. Very much looking forward to the good senator from Lakeville being a co-author on that bill. So here's what I can tell you about paid family and medical leave. If your employer offers a program that is as good as or better, they can opt out. If your employer offers a medical program that's as good as or the state's or better, they can opt out of the family leave. Or they can opt out of the medical and they can stay in the family leave, or vice versa. So there is a lot of flexibility for companies, businesses, corporations to offer as good as or better benefits than what we have here. In addition, there's nothing that prevents companies from replacing or topping off, I should say, the partial wage replacement to get them to 100% wage replacement. But again, I really think we're going to get to 100% wage replacement next year with how many Republican colleagues have expressed their support for it. And then the last thing is that Minnesotans are not prohibited from using PTO or sick time or any of the things that they have at their company before they take paid family and medical leave. So if you have banked like Senator Farnsworth said he has like 100 sick days, he is more than able to take 100 sick days before going into paid family medical leave if he needed that amount of leave for whatever reason. So this is an incredibly sustainable, flexible, wonderful program that attunes to the unique needs of Minnesotans and the unique ways that businesses and corporations and groups are organized. And so, Mr. President, I will respond to Senator Duckworth and say that this bill is a reflection of all of the work that Senator Mann did with all the interested stakeholders, people who opposed the bill, people who support the bill, to make sure that it reflects our values as Minnesotans, but also responds to concerns and the unique needs of our state, which means that Minnesotans in that first kind of income bracket, that bottom one, 90% of your wages will be replaced. When you head up above that, 66% of your wages, and then above that, it's 55%. So we will have strong wage replacement, but I think I have a co-author on my full wage replacement, and I'll be candid with you, Mr. President, I'm just talking a little bit longer so that you can get back up into the dais. I don't need to keep repeating myself. Thank you.
Senator Duckworth.
Thank you, Mr. President, and thank you to Senator May Quaid. And I can appreciate the comments, although I won't be as flippant when it comes to the questions that people have in terms of whether or not they're going to receive 100% of their pay or not under this mandated program. I think there are a lot of valid questions that people have in terms of what this is going to mean for them, their families, and their pocketbooks. If they're thinking that somehow this plan may or may not be better, comparable, or worse than the benefit plan they currently have under their employer, that's extremely important for them to know. Because, Mr. President, here is the situation we're going to find ourselves in once this actually becomes law. Many employers out there are going to have to make a very difficult decision. Can we afford to self-insure, and are we going to go the route of paying a surety bond? Am I going to have to try to look to pay, get an insurance policy, pay the premiums and the fees to the state, even though I've got an insurance policy to cover this? Or are we going to have to go all in on the government program, even though we're already offering maybe 6 or 8 weeks of 100% pay to our people? Maybe we already offer 12 weeks of full 100% paid leave. But for whatever reason, based on the advice we get from our accountants, our tax folks, etc., we have to go with the government mandated program. That's what's at stake here. We could actually be taking a step backward in terms of benefits, flexibility, and options when it comes to employees and the workers of Minnesota and what they're afforded from their employer if their employer is forced to go this route. That's what's at stake here. So as much as we want to try to pit Republicans against the hardworking people of Minnesota, the moms who are giving birth and taking care of their children, the dads who desire to be there at their side during that process, somebody who has a loved one with a medical emergency that wants to be by their side, we get it. We feel compassion for every one of those people, which is why we have brought forward another option to give them the freedom and flexibility and option to still do those things, but in a way that's way less rigid. So I'm not going to continue to do that and make this argument one in which we're trying to wedge or pit sides against each other, because that's not what's happening here. What you have are two parties that agree on paid family medical leave, but want to have an honest discussion about the different ways in which we can do it, Mr. President. And that's how I'm going to continue to have this conversation. When I look at page 29, on line 29.8, this is under vacation, sick leave, paid time off, disability insurance payments section of the bill. It says an employer may offer supplemental benefit payments as defined in a section of law to an employee taking leave under this chapter. But then it goes on to say on line 29.12 and 29.13, the total amount of paid benefits under this chapter and the supplemental benefits paid must not exceed the employee's usual salary. Now, when I read this as an employer, one of my first questions becomes, well, let's say I've got an employee, we're utilizing this program, they're getting their checks from the state of Minnesota as it relates to their paid family medical leave, but they just had a kid, and as an employer, I would maybe want to give them a little additional pay to honor the fact that they just had a child, to help make ends meet, and really just to be generous and say, I'm thinking of you and your family. However, if I were to do that as an employer, it cannot exceed the employee's usual salary, and if it does, they're going to lose the benefit for that week. Well, I think that's concerning, and that gets to some of the issues regarding flexibility that I keep talking about. I think we want a plan that gives employers and employees the maximum amount of flexibility possible. When we go down to subdivision 7 on the same page and we look at lines 29.27 to 29.30, this is under separation, severance, or bonus payments. It says, an applicant is not eligible to receive benefits for any week the applicant is receiving, has received, or receive, and I want to focus on this portion, bonus pay, or any other payments paid by an employer because of employment. So this leads me to ask the question as an employer, well, if I pay an employee who's on this leave program a bonus while they're on that leave program, is that going to make them ineligible for a payment from the state-run family paid medical leave program? And if it does, I don't think it's right, because that employee may have earned that bonus or may have hit a metric or been a part of a team that hit a metric before they even went on the leave program, but for whatever reason, whether it's payroll or how long it took them to actually achieve the goal for the bonus, would be paid to them during that time. And so what I don't want to see is people either A, losing the benefit that they're entitled to because they're getting a bonus from their employer, or for them not to be paid that bonus out of fear that it's going to negate or cancel the payment they would otherwise get under the paid family leave program. As you can see, the theme here, Mr. President, is really just about flexibility. That's what this plan is missing. There's no flexibility for employers and employees to do right by them, their situations, their family, and all the impossible scenarios that might arise. That's what's missing in the program before us, so why I think it needs to go back to conference committee. We need to do this. If we're going to institute paid family medical leave in the state of Minnesota, we need to do it in a way that maximizes freedom, flexibility, and options for the hardworking men and women of our state and those who employ them. That's what we need to do. I'm not going to talk about the fees that are still going to be assessed to businesses even if they choose to do the insurance option, but I will talk about this. On page 71, section 40 talks about small business assistance grants. And oftentimes, we kind of get vilified for saying that, this is going to have a negative impact on small businesses, or for acknowledging the simple truth that it's going to come at a pretty substantial expense for them. God forbid we be mindful of our small business owners who employ nearly 50% of the state of Minnesota. But that provision in there, the fact that there is a provision in there that would allow for grants for small businesses as a result of this program being implemented is an admission that we think it's going to be a financial strain for some of our businesses here in Minnesota to abide by this program. So for those that say our small businesses are going to be fine, this only costs a little bit of money, there's nothing to worry about, they've got the profits to take care of it. Well, if that was all true, why in the world would there be a provision in the bill to provide those small businesses and those employers grants if we think there's not going to be a financial issue? And this is the last thing I'll say, Mr. President, because it kind of goes along with that. You know, we keep hearing, oh, for only the steal of $3.37 a week, we can afford this program. That's great. I mean, if that's a worthwhile investment, takes care of people, I can appreciate that. But what we're seeing as a result of this session, Mr. President, is a little here, a little there, you know, a little bit of a gas tax here, a little bit of a fifth-tier income tax here, a delivery tax on your Amazon deliveries here, and an increase to your car registration tax here, etc. That's what needs to be examined holistically, Mr. President, because all those little heres, little theres add up very quickly to about $9 to $10 billion in tax increases on the very same hardworking employees of the great state of Minnesota that we're talking about, trying to help them afford their lives and their cost of living. That's what we have to be mindful of. And every time I hear just a little bit here or a little bit there, what I hear is, if we just reach into this pocket of the people and this pocket, and pretty soon we run out of pockets to reach into, Mr. President. And the people of Minnesota are the ones bearing the cost. And in this case, we're going to have them bear a pretty substantial cost, and what they're going to end up with is much less flexibility, much less freedom, and way less options as it relates to their employment benefits in general and paid family leave. So what I'd love us to do is to come together with a truly bipartisan approach to paid family medical leave here in the state, Mr. President, one that honors our employees and employers, does right by them, and saves all of them, quite frankly, quite a bit of money in the process. Thank you.
The great senator from Lonsdale, Senator Liskey.
Thank you, Mr. President. I would like to thank everybody so far for this wonderful debate. I'm not generally one to enjoy long, drawn-out discussions at any time. I like to be very concise about my points. And the unfortunate part is today that I've sat and listened to this, and I get more confused, not less, listening about this bill. And so I'm in support of Senator Draheim's motion because it sounds like, as senators from Lakeville, St. Michael, and Blaine have drawn attention to, page 14 is a very concerning and not very clear organized page. And so would Senator May Quaid from Apple Valley yield for a question?
Senator May Quaid, will you yield? She said yes, she will yield. Senator Liskey.
Thank you, Mr. President. Thank you, Senator McQuaid. I am concerned reading through this as a self-employed individual myself, and concerned for other small businesses, mostly strictly their own families operating those businesses, as my wife and I only operate our business. We don't have any other employees currently. And reading through it, it's not very defined on how I would have to handle paying my wife, as she's not technically listed as a owner of the business, but she is technically self-employed still, I believe, under federal law. So could Senator McQuaid answer me as to whether I would have to now cover this for my wife?
Senator McQuaid.
Thank you, Mr. President. So wage details that are reported for employees are people who would have the premiums collected for.
Senator Liskey.
Thank you, Senator McQuaid. Thank you, Mr. President. I guess that's still kind of unclear, as her employment would still be recorded under my own business, and so she still makes wages, but she doesn't have the same wage laws as we would define as employees. So it gets kind of an interesting and intricate part of the business. So with that, we'll kind of move on, because I don't think there's a good answer there. I've been digging all day trying to find the answer to that. So I'm going to move on to a different question. I have some friends that work in IT, and as Senator Lucero has already kind of worked towards, and he drew up a bunch more questions for me. So would Senator McQuaid yield for another question?
Senator McQuaid will yield. She says she will yield. Senator Liskey.
Okay, so a perfect example, I have a good friend of mine who works in IT. He lives here in Minnesota. He works from his own home office. So by definition, I think technically works here in Minnesota, but he works on servers that are in New York or Virginia or even in Europe. So technically the work he's performing is actually on those servers. And so those would be not in the state of Minnesota. His company is in California and New York. So again, those are not in the state of Minnesota. Would his employment be still considered and defined under the state of Minnesota here by that definition?
Senator May Quaid.
Thank you, Mr. President. And to answer Senator Liskey's earlier question, I didn't catch the part where he said his wife's not an employee. If she's not an employee, then he wouldn't have to cover her. It's very clear. To the second piece about the IT tech person who works in Minnesota, yes, he would, I assume, unless he doesn't work for just himself, if he works for a company. If he works here in Minnesota, yes, he would be covered by this program.
Senator Liskey.
Thank you, Senator McQuaid. Thank you, Mr. President. Mr. President, I have one more question if Senator McQuaid would yield.
Senator McQuaid, will you yield? She says she will yield. Senator Liskey.
Thank you, Mr. President. Thank you, Senator McQuaid. Okay, so I'm going to set up another scenario that another friend of mine interacts with. It's not as common as Minnesota generally is not the hub for a lot of servers and storage of servers, although we do have some. This individual works for a company. The company is based out of Virginia. He lives in Virginia, but the servers that he does work for are here in Minnesota. And so technically, by these definitions that we have here on this piece of legislation in front of us, he would be performing work in the state of Minnesota, but not actually work for a company in Minnesota, would not live in Minnesota, but the work would be here, technically, in Minnesota. So would he and his business now have to pay this specific employment tax?
Senator McQuaid.
Thank you, Mr. President. Senator Liskey, I really am going to refer you to lines 4.9 to 4.17. Without knowing how much time your friend spends in Minnesota working, I can't quite say, but it doesn't sound like he lives in Minnesota or works more than 50% of the time in Minnesota, so he wouldn't be covered by that.
Senator Liskey.
Okay, thank you, Mr. President. Thank you, Senator McQuaid. So, like I said, the job that he's performing, because the words performed are here, the job he performs is in Minnesota. The work he's doing, technically, is in Minnesota. Now, where he's doing the work is actually not in Minnesota, but the work being done is on servers in Minnesota. So if Senator McQuaid could yield for another question.
Senator McQuaid, will you yield? She says she will yield. Senator Liskey.
Thank you, Mr. President. Thank you, Senator McQuaid. Again, this question, I think, does imply that by reading this, at least the way I interpret the words performed in, he would fall under this. But again, the company has no connections to Minnesota other than the location of their storage, their servers, and the employer and the employee both have no connections other than the storage of those servers. Does that mean, even though by reading this, he would be performing his job in Minnesota, he falls under this?
Senator McQuaid, the question again.
Thank you, Mr. President, and I think I misheard. Senator Liskey, he implied that he was coming here to Minnesota, but if he is in a different state and he is not working in the state of Minnesota, he is not covered by this. This would not apply to him.
And I just want to make sure that I'm clear on the scenario, and that'll help you. You were saying your friend works in Virginia, lives in Virginia, does work in Minnesota, or does no work in Minnesota?
Mr. President, I'll answer that. So he does not actually live or work. He works from his home office. He does computer work using his computer, but he's affecting and performing jobs on servers here in the state of Minnesota. I know it seems very odd, but now we're getting into the virtual world, and with the way this is worded currently, he is performing a job in Minnesota on Minnesota servers. Does that make sense?
It. So, Senator McQuaid, we'll go back to you. Members, just so you know, I kind of sometimes ask clarifying questions because I actually follow along, so I don't just stand here because I'm good looking. Okay. Okay, you don't think I'm good looking. Okay. But I really try to follow along to help make sure that we are communicating. Senator McQuaid, to the question.
Thank you, Mr. President. So server location is not work location. Work location is what matters. So your friend, Senator Liskey's friend, who lives in Virginia and is working out of his home in Virginia is going to be subject to the laws and taxes of the state of Virginia.
Senator Liskey.
Thank you, Mr. President. And that's what I wanted to clarify, because like I said, as I'm reading this bill, I am concerned that with the way it's worded, you could argue, or someone could argue, that he is performing a job in Minnesota. And so that is why I support the Draheim motion, because I think we need to clarify some of this language to make sure that it is properly defined. Thank you.
All right, we are now going to the great senator from Brownsdale, Senator Dornick.
Thank you, Mr. President. I've too enjoyed the debate. This is a very important subject. Paid family leave is important to everyone. I appreciate the careful, respectful debate. This is an emotional issue. It affects families, it affects kids, but it also affects businesses. And as I've mentioned many times, there's that delicate balance between labor and industry and the employee and the employer. And I had mentioned before, but we'll just kind of go through, there's over 500,000 small businesses in Minnesota. And 94% of those businesses have 50 or less employees, which is about 470,000 people. So we're not talking big corporations, we're talking small families. And families that have wives, that have children, that get sick and have to go to the hospital. They have to do all those things too. And plus they're running a business and they're trying to provide opportunity and jobs for the people in the community. I'm just going to mention a few people in the community that I've talked to that starting a business is not easy. And so I'm going to talk about Robert. He has a real estate business in my district. He's been working in real estate for 20 plus years. Him and his wife worked really hard, and they work still 12, 14, 16-hour days. And the 3 employees that they have, they're like family. And they work with them, and they give them time off when they need it. And that's what most Minnesotans do. Now, there is opportunity, or there's some instances where we need to deal with some that are bad actors, but most aren't. And then I want to talk about Rita that I just met not that long ago, just started a business, a restaurant business, took a chance. The business had been closed due to the pandemic, and she wanted to start her business, and to try to find help is really difficult. And she actually hired one of my daughters, and so I got to see just how hard they work and how hard she's working to try to make this business survive. And she's asked through my daughter, well, what's happening, and how's this going to affect my business, and what's this going to do? Because many businesses are pretty tight, and they work hard and a lot of hours. So it's not just about the, again, that's that relationship, those workers working for these employees, partnership, so important. And then I'm going to mention 2 others. Tom has a bowling alley, and I've gone there many years. It's one of the small towns that I represent, and he bought the business 30 years ago. And whenever I go in there, I see him almost every time, working 12, 14, 16 hours a day, and having the relationship they have with the workers. That again, these small communities, everybody knows each other, and we take care of each other. And lastly, I'm going to get to the agriculture part, because ag is huge in southeastern Minnesota, in District 23. It's so important. And agriculture, there's still a lot of small farmers out there. We have a neighbor that it's either 3rd or 4th generation business or farm. And when you can go 4 businesses on anything, I don't care what it is, if you can keep it going for 4 generations, that is it's a great feat, and it should be recognized that how that is passed down to family to family. I love to see that. I'm just going to talk a little bit about, I don't like to talk about myself that much, my story. And one thing that we don't want is for those unintended consequences. And the economy, I don't know how many people across the aisle have businesses or small business owners, but the economy is slowing down. I'm the trades and the carpenter yet, so the economy is slowing down. And what we don't want is those good, hard-working people that are working for small businesses to be laid off. Because I know what it's like to be laid off in the construction trade that Senator Rarick was talking about. When you're in the trades, you get a check once a week. And when you don't work anymore, the check stops. You have unemployment, but it's pretty tough when you have a larger family like I have. And so I got laid off in 2009 like a lot of Minnesotans did. And that is very stressful. The pressure. When I got laid off, I didn't know if it was Thursday night. I got laid off. Been there for many years. My wife was actually in Florida with the kids, and I wasn't going to tell her that I didn't have a job when she came back home. I was going to let her enjoy that time. So that's what we don't want. That's what we're concerned about. We care for those and appreciate the workers and want them to have that time off to bond with a new child. If they're sick or need to help with a loved one that's maybe on the last few days of their life. So that's not what it's about. It's about those unintended consequences, Mr. President. So I'm going to go to the process a little bit. So this bill came in Labor and Industry back in January. It was one of the first bills that we heard. And, it comes quickly, and you got to read through this stuff and to try to get these, as you make laws, there's just many words, and every word means something. Every sentence means something. So we're going through trying to figure it out with the team that in the Labor and Industry Committee, and trying to find out, okay, is this going to work? Is this? And then meeting with stakeholders and talking to agriculture and talking to business and talking to the workers and the employees, the employers, all that trying to get, okay, is this going to work? How about this? It's going to cause a problem. And so we got our amendments together real quick because it was, again, things are moving pretty quick as they've continued to do all through this session. And so one of the big things that we saw was the agriculture community, and we did an amendment. I got some of the stakeholders and helped me write the amendment, and they did it really precise to help the exact industry and the effect of how this bill is going to affect. And I had talked to the author to see if we would be able to have this amendment accepted. We chatted about it. It was voted on. It was voted down, which was an exemption for seasonal workers for agriculture, Mr. President, because in the farm community in the spring, that's when things are really busy. They need help for rock picking. They need help for driving truck, field work, getting all that stuff in a timely manner. Because the sun doesn't always shine. This year is kind of a wet spring, so they got to get in and get the work done quickly. And so with that was a real important thing, and I have yet to have that I've heard of any farmer that wanted this provision in here. They wanted an exemption. They wanted an option. So with that, I'd like to see if Senator Putnam would yield for a question.
Senator Putnam is not in the chambers.
Oh, thank you, Mr. President. Mr. President, how about Senator Kupek? Would he yield for a question?
Senator Kupek is not in the chambers.
All right. Well, I guess I'll continue to talk about how important this is. So my point was going to be just that Senator Putnam, being he's in the Agriculture Committee, that he would have talked to a lot of farmers too, and I wanted to see what he had heard about from those conversations. And Senator Kupek was in the Labor and Industry Committee with us. So anyways, but I have yet to hear support for that. Just a lot of concern. And I was going to switch to the fall. The fall, the same thing. It's real busy. Time is important to get that crop out as soon as they can. And the people that are working are many times retired people that just want to do some extra work and help out their neighbors, their friends, sometimes their relatives. And this just puts an extra burden on them. It's not about that we don't care about them. It's just, again, those options, being flexible and not listening actually to the stakeholders in the agriculture community that I have talked to, and I don't see any support. Now I'm not talking about the small, I'm talking about the small farmers, boots on the ground individuals, the farmers. That's who I'm talking about. The bigger full-time workers that work in some farm business and stuff. I'm not talking about those. I'm talking about those little farmers that are just sometimes, a lot of times, father and son or family. Mr. President, is Senator Kupek
Senator
be willing
Kupek
to
just
yield for
returned.
questions?
Senator Kupek is here. Would you like for him to yield?
Yes,
or
I
ask
would.
me if he wants to yield?
Yes.
Senator
Mr.
Kupek, will
President.
you yield? He will yield. Senator Dornick.
Thank you, Mr. President. Thank you, Senator Kupek. So I just was talking about agriculture, and I know we talked about it earlier a little bit, and I had something I had to attend to, so I missed some of your testimony. But so I was going to ask you, I was just saying that in the conversations I've had with the farm community, the farmers, I have not found any support for this paid family leave for those in the, again, the seasonal workers, but the farmers trying to get help in the spring and the fall, getting their crops in and taking them off. So my question is, did you have a conversation and did you have support from, I know some of the Farm Bureau or some of those other organizations?
Senator Kupek, to the question.
Thank you, Senator Champion, and thank you, Senator Dornick. Yes, so as I stated earlier, because of the languages when you're trying to make specific carve-outs, and we're looking for jobs that are in statute to qualify. When we went with seasonal workers, it was a huge chunk of the workforce and people that we want this to be able to have this benefit. So seasonal worker just didn't kind of work for that. And then when we were talking with people from DEED and we were trying to wrap our heads around how we could do this, obviously there are people who work in the agricultural sector that we would also like to have this benefit. And Senator Dornick, I know exactly the kind of people you're talking about, those people who are retired and they pick up a couple of shifts here or there. When the harvest is coming in, they drive a truck and they make a few extra bucks while they're doing that. And those are people, if we could find a way, I think, to carve that out, because those are probably people who are maybe not looking for this paid family medical leave advantage to do that. I think that would be worth exploring at some point. But the way our statutes are structured, there just aren't. And there just are people in that agricultural sector that want that. And even if you're doing that part-time, maybe you have another job and you just fill in, you drive the truck a little bit during harvest. This benefit is portable. So even if you're gaining those wages, say you went out on some leave in the winter from whatever your regular full-time job is, you'd actually get a little bit higher benefit, because if they go back and look at the quarter of what you earned for wages, then you'd have a little bit more in that account from working that job in the fall for harvest. So there is also some benefit for doing that.
Senator Dornick.
Thank you, Mr. President. Thank you, Senator Kupek, for that. So, Mr. President, if Senator Kupek would yield for one more question.
Senator Kupek, will you yield? He said he will yield. Senator Dornick.
Thank you, Mr. President. Thank you, Senator Kupek. So my next question is that carve-out. I know that in the committee, we tried to get one carve-out, and it was pretty firmly rejected and said that we're not going to allow any carve-outs. And now I see there is one for hospitality, which I'm grateful for, and I appreciate that. So I don't know if this would be a question that you would be able to answer, Senator Kupek, or not, but I'll start with you. So my question is, the hospitality was carved out. Again, I appreciate it. I know you kind of explained some of it with the agriculture being a little more complicated, but hospitality looks pretty complicated too.
Is that your question, Senator Dornick?
Yes, Mr. President.
Senator Kupek, to the question.
Thank you, Senator Champion. Thank you, Senator Dornick. And I'm not sure I can totally answer that. I believe that carve-out happened somewhere on a committee where I was not a part of. But I think the part is that when we talked with DEED, they recognize that in Minnesota state statute, there is something that talks specifically about hospitality. So it was an easier one for them to identify.
Senator Dornick.
Thank you, Mr. President. Thank you to Senator Kupek. So legislating and making laws is complicated, Mr. President. As we see, trying to carve out a real important sector, and that it sounds like it was just too hard to do, maybe, or too complicated, or maybe Maybe we're just moving too fast on this, and that's why I rose to support the Draheim amendment to maybe to slow this down and have this looked at. And that's one thing I've learned here, Mr. President, is complicated. There is so much to legislating, and there's so many things, there's so many words, and words have meanings. And we have to make sure that we don't have the wrong words in the wrong spot. But I'm going to speak to just a little bit, page 18, line 1810, talking about, for the purpose of this section, hospitality has been given under the collective definition in section blah, blah, blah. So, but I pulled the exemptions, which are, it's pretty interesting. It's actually 2 pages. It's one page, but it's both sides. So I'm not going to read it all, but just how specific we have to be as we legislate. So we have food cart. Food cart means a food beverage service establishment that is non-motorized vehicle, self-propelled by the operator. But then we got to go to a mobile food unit, which we're grateful that they serve us out here just in front of the Capitol. A mobile food unit means a food and beverage service establishment that is a vehicle-mounted unit. So there we go. And then we go in the back, and there's more. And again, I'll just do a couple more. Just I think there's 13 to 15 different ones. But we'll go to school concession stands. So we have to exempt school concession stands. Can you imagine, Mr. President, having kids that are in school to try to have the paperwork and all the things that would be involved in that? Then we have a special event food stand. Special event food stand means a food and beverage service establishment which is used in conjunction with celebrations, special events, and which operate for no more than 10 days within the license period of time. And the last one, the seasonal temporary food stand. So there we go to the seasonal. So again, we have the seasonal part here for hospitality. Grateful for that. Agriculture could really use that exemption also. So in closing, Mr. President, again, small businesses, some people don't, well, rephrase that. It's a dream for many to own a small business, to be able to work on your own, and the hours, the sacrifice to do that. We don't want to, we got to be careful that we don't hurt those dreams of starting a new business, especially a family business. There's nothing more enjoyable than a family business. And then also for those dreams, and there's hopes for those employees that are working with and have worked for many years, or some of them new, that have started to make those relationships with those small business owners, with their families. They know their kids. They know both the owner's kids and the owner would know their kids, and those relationships and how important they are. So we want to be so careful as we're legislating that we don't hurt anyone in Minnesota, that we're careful legislators. So I guess the last point I'll just make is, again, talking about how important it is that we had a carve-out for hospitality. And there's other things, and the other is many of the businesses, like I mentioned, are small businesses. I would think of 10 or under would hit a lot of businesses that, as I'm walking through, or yeah, actually going through the communities and visiting small business owners and getting the feel of what's going on up here, and they are definitely very concerned. And they just came out of a pandemic not that long ago, and we lost a lot of small business owners then. And many of the small ones are just starting to recover. We had a good year, and we just, again, need to be careful as we're legislating not to hurt those that are employees and those that are employers. And so with that, Mr. President, I do support the Draheim motion, and do think that we need to work somehow to get this exemption for the agriculture, and be more careful that we don't have unintended consequences. Thank you, Mr. President.
The good senator from Stillwater, Senator Housley.
Thank you very much, Mr. President. Senate District 33 is otherwise known as God's country. Mr. President, we Republicans, we support efforts to expand access to paid family and medical leave, and I do too. But this program falls short of what Minnesotans deserve. It creates a bloated government bureaucracy, 400 plus employees. Senator Eskowski and I were just trying to count them all up, and we're pretty sure it's going to be more than 400 employees. It's also going to require a massive tax on employees and employers, and it's going to eliminate current paid leave offerings already available to a bunch of employees. There is no, if you like your plan, you can keep your plan with this proposal. Many employees and employers have worked to develop programs that will work for many of them and serve their needs. And this proposal is going to throw all of that out the window and force everyone into the same statewide plan. I was just talking to an employer in my district. It's a small contracting firm whose employees are not going to be happy when the Democrats pass this bill. This firm has a much better paid family and medical leave program that they offer to their employees. As a matter of fact, they offer their employees 4 months of maternity leave, paid maternity leave, but now it's only going to be 3 under this bill. And their employees don't pay for that at all. But now, based on this bill's formula, those employees are going to be paying half of their own paid medical leave in taxes. And at this firm, if the family has a member that's sick and needs to take care of him, they actually sit down and they work out a plan together, but that's not how it's going to be anymore. Employers, what is going to be the reason that an employer is going to want to keep their plan when there's this government-mandated plan? Mr. Chair, would Senator May Quaid yield, please?
Senator May Quaid will yield. Senator Housley.
Thank you, Mr. President. One of the questions that this employer in my district asked is, all right, if they are going to continue with their plan to try and entice and keep employees, who do they have to let know that they have their own plan?
Senator May Quaid.
Thank you, Mr. President. Deed.
Senator Housley.
Thank you, Mr. President. And what criteria is Deed going to be using? What comparisons are they going to? So this plan, they have 4 months medical or 4 months maternity leave. The state plan is just 3 months. Their plan has no paid medical leave, and the state has 3 months. What is there a side by side which says this plan is better than that plan, so then you can continue to offer it? How is that going to be decided at Deed?
Senator May Quaid, you are requested to yield. She will yield. Senator May Quaid.
Thank you, Mr. President. To Senator Housley, so Section 19 of Article 1, it lays all of this out. And we actually separate out medical benefit program and the family leave program. So the company, and I didn't catch the name, that offers 4 months maternity leave, which is amazing if they offer it to all of their new parents. So fathers, mothers, or people who consider themselves new parents, they would be able to opt out, and the private family or the private plan requirements for family leave start on 43.6, so you can read all of that there. They have to be covered under the employer plan. They can't be more restrictive than this chapter. The weekly benefits have to be at least equal to the weekly benefits. Sounds like this company does 100% wage replacement, which is, of course, above that. The total number of weeks have to be at least equal. They go above that. So on and so forth. Because they do a more generous, it sounds like, family benefit program, they can apply for an exemption from the family benefit, and then they can still opt into they can still be part of the medical benefit for the state plan, or they can decide to go with a medical plan for their company that is as good or better, and then they would be able to opt out entirely.
Senator Housley.
Thank you, Mr. President. Senator May Quaid. Again, if I'm a small employer, everything that you just said sounds like a very complicated thing for them to have to do when they already think they have a pretty good plan going. I think many of our small employers are just going to say, hey, sorry, you know what? Now you guys, my employers, sorry to tell you, but you are going to be having to pay a tax to get any sort of paid family and medical leave. It's not what they want to do, but it's what they're going to have to do. And again, I understand what the Democrats are trying to do here. Not all employers have these plans, and not everyone has these benefits. But we Republicans, we had that plan. We had that plan that would have worked. We had a paid family and medical plan that we proposed for the last 2 years. So unfortunately for businesses and local schools looking to finance this new huge government bureaucracy, they're going to have to find the money to make it work. So I don't know if anybody that's going to vote for this has talked to their district superintendents, but this is going to cost them a lot of money. I don't know if you've talked to your school boards, but this is so very costly, and that's money coming right out of the budgets for everything else, coming out of their curriculum budget. They are honestly worried about this right now. How are they going to pay for it? Are they going to have to take money from, are they going to cut their orchestra program? Are they going to cut sports? Are they going to cut their gifted and talented program or their robotics program? Or maybe they're just going to cut out busing. I mean, some of them already can barely afford busing, but you know what? Maybe they're just going to have to completely cut out busing. And on top of that, our schools can't even levy for this. They can levy for other things, but they can't levy for paid family and medical leave. So it's just another costly mandate that we have put on our schools when they're just trying to make ends meet. If they're a local government or school struggling with these mandates, they're going to have to look at raising taxes, reducing staff hires, or even cutting some benefits that they already offer to their employees. So if you think, folks, if you think your property taxes are high right now, take a snapshot today, when are we at? May 18th. We're not adjourning today. May 18th. Take a picture of what your property tax bill is today, because that's the lowest it's ever going to be. And that's scary. But folks, we had a plan. We had a plan. Senator Coleman had her plan. We all voted for it. We wanted to do it. The beauty of our plan is that we supported that it actually lets employers keep the plan that they have, and employees can benefit from that. Unless you're a big company, it's going to be awfully hard to afford this, but the plan we had would have been much more cost effective. Remember, this bill applies to any small business that has an employee. So in the real estate world, we have, you have individual real estate agents, and many of us have transaction coordinators. So from what Senator May Quaid told Senator Liskey, is if that transaction coordinator, who, by the way, is licensed in the state of Minnesota, lives in another state, they would not have to, the employer, say that's me or Senator Duckworth or Senator Jasinski, they would not have to pay this tax for paid family medical leave. But if that real estate agent has a transaction coordinator as an employee and lives in this state, they do have to pay that. Would Senator May Quaid yield, please?
Senator May Quaid, will you yield? She will yield. Senator Housley.
Thank you, Mr. President. So under that scenario, Senator May Quaid, the real estate agent with the transaction coordinator who lives in the state, just one employee, lives in the state, they would have to pay this tax, correct?
Senator May Quaid.
Thank you, Mr. President. They would pay the insurance premium if they live and work in Minnesota.
Senator Housley.
Thank you, Mr. President. So if that transaction coordinator, which I am telling you there are a gazillion transaction coordinators across the US, Canada, around the world, who are constantly emailing us that they would love to have a job. If that transaction coordinator lives in Ottawa, Ontario, and is licensed in the state of Minnesota, the real estate agent would not have to pay that insurance premium.
Senator May Quaid, you're asked to yield. She will yield. Senator May Quaid to the question.
Thank you, Mr. President. I think I need clarification. So the transaction coordinator is in the state, but the real estate agent is out of state. Did I hear that correctly?
Senator Housley, clarification.
Mr. President, the real estate agent is licensed in the state of Minnesota. The transaction coordinator is licensed in the state of Minnesota, but doesn't live in Minnesota. Earlier, Senator Mayquade, to Senator Liskey's point, if the person lived in Virginia, then Senator Liskey did not have to pay the insurance premium.
I think the issue there was working on a server, which I think is the difference, but I don't know that. Senator Mayquade.
Thank you, Mr. President. Yeah, I think we're conflating examples here, so I'll just restate it again. If people live in the state of Minnesota more than 50% of the time, or if they work in Minnesota, they are covered by this. If they are in another state and doing work in another state, they are not covered by this. I'm not sure. The language is incredibly clear, Mr. President, and I think coming up with these examples are trying to confuse people about who is and isn't covered. So if the real estate person in Minnesota is their boss and pays the wages of the real estate transaction person who also lives in Minnesota, yes, they would be covered. I believe I have answered the question, but I'm not 100% sure if it was asked that way.
Senator Housley.
Thank you, Mr. President. I think I'm still getting that if my transaction coordinator was virtual and lived in another state, I would not have to pay the insurance premium. Would Senator Duckworth yield?
Senator Duckworth will yield. I thought you were just over there, Senator Duckworth, but I guess we're going to yield to get on the mic. Senator Duckworth.
Mr. President, Senator Duckworth, he was over here, Mr. President, and he also employs transaction coordinators. So, as you understand it, Senator Duckworth, would you have to pay a transaction coordinator that lives out of state?
Senator Duckworth.
Thank you, Mr. President. Thank you, Senator Housley, for the question. I think this demonstrates exactly what many business owners, employers, and employees are going to have to work through as a result of this bill. And to the comment earlier, these are not hypothetical situations or scenarios that are being proposed in order to confuse people. These are situations and scenarios being proposed that actually illustrate and highlight just how confusing it's going to be for folks. And so here's why I'll tell you why that's important, Mr. President. In Senator Housley's example, I do employ multiple transaction coordinators as part of one of the businesses that I own as it relates to real estate. And what I can tell you is they're going to be, if I choose to do the government mandated program, which I'm probably likely not going to do as an employer, but if I have to use that program, yes, of course, we're going to have to opt into it with those employees, and we'll likely do that. But what you're going to have some business owners do, or what you're going to have some employers choose to do for workers, like the workers in this scenario, which can work remotely in places outside of Minnesota, is ask themselves this. They may not do it, but a good business owner and employer might ask themselves this question: is it going to be more beneficial for me and my business to hire somebody who works remotely that lives outside the state of Minnesota rather than in the state of Minnesota due to some of the intricacies of this bill? In which case, it gets back to some of the points I was making earlier, Mr. President, is this: are we actually going to be incentivizing Minnesota businesses or Minnesota employers to not hire the very people that live within our state, or to potentially move the headquarters or base of operations that they have to a bordering state? And that's why I appreciate the question, because what the question highlights is the employers and employees that are going to be struggling and grappling with these decisions in order to meet the needs of their businesses and their employees. And I can tell you this: if I had the option to choose something way more flexible on behalf of my employees, I would do it in a heartbeat compared to this program. So I appreciate the question.
Thank you, Mr. President.
Senator Housley.
Thank you, Mr. President. That was exactly the point I was getting to, is this going to incentivize employers to not hire people living here in Minnesota and to go across our state borders or country borders? I don't know, but it's a question out there. And again, we had a plan. We had a plan that we supported where insurance companies would be able to sell paid family leave insurance, and the state would help them with the tax incentive. It's faster. It doesn't require hundreds of government employees, and it doesn't take away plans for the people that have them. Members, this is a massive program. and it's going to be way too costly for Minnesotans, and it's actually going to harm entrepreneurship and business growth across the state. Members, vote to send this back to conference committee to get it right, get a plan that works for all employees and employees here in Minnesota. Thank you.
Senator, the great senator from Wyoming, Winona, Senator Jaskowski.
Thank you, Mr. President. That would be Senator Miller, Mr. President, from Winona.
Well, someone has given me bad information.
Okay.
Let me just say that. So let's blame it on the scribe.
Okay. I am from Mazeppa, Mr. President.
You can definitely correct me.
Yes, I'm from Mazeppa, Mr. President, but thank you. I do own a small business in Winona.
Okay. See?
So
you got businesses everywhere, Senator.
We really are getting down to business here, Mr. President. And this bill will negatively affect businesses. As a small business owner, I can tell you that small business owners and large business owners across Minnesota have their employees first and foremost in their mind as they manage their businesses, because their greatest asset, Mr. President, to any business owner is their employees. And if you don't treat your employees well, your business won't last long, and that's just the way it is. What we have here, though, is a government program that's coming in and trying to replace or displace the employer. That's what we have. Members, there is no virtue in government. Government just is and does what we direct it to do. Government is not a virtuous entity, but I'll tell you what, people are. And it's people that run our small businesses. It's people that work at them. And trying to displace that and pretend that we're going to create this government bureaucracy and the machinery around it that is somehow going to have human characteristics that can figure out how to manage people and manage priorities and help those people meet their goals I think it's a fallacy. But that being said, Mr. President, I do have some questions on the bill. By the way, I do support Senator Draheim's motion. I think we need to send this back to conference committee. It needs a great deal of work. It way too much impinges, infringes, and provides oppression to that employer-employee relationship. You know, the first item in the bill that I really highlighted was the item that Senator Housley and Senator Duckworth were talking about here just a minute ago, and that is on page 14 of the bill. I mean, I'm going to read the language, members. So if 50% or more of the employment during the calendar year is not performed in Minnesota or any other state or Canada, but some of the employment is performed in Minnesota and the employer's residence is in Minnesota during 50% or more of the calendar year, you get to pay this tax. So, as I read that, members, Mr. President, that is disincentive for people who just want to work without the government coming in and telling them what to do. That is disincentive for them to stay in our great state. I mean, Mr. President, I know so many employees that all they want to do is work. And we have government coming in and dictating the terms of employment to them. And it's throughout this bill. I mean, we'll get into some of the examples. Here's an example here. It's telling them that they have to be part of this program if they're under these conditions. Mr. President, members, we heard recently some of the data that's come out about people fleeing this great state of Minnesota. Mr. President, they're getting out of Dodge. They're getting out of Dodge right now. They've been getting out of Dodge for the last couple of years, and it is picking up in intensity. I got a text from a good friend of mine yesterday Steve, we're moving to Florida. And so I said, well, is it because Minnesota is no longer bearable for you to live and work and raise your family, or is it because you found a great job? He said, both. We got to pull our head out of the sand, members. People will vote, in addition to voting at the ballot box. The best way that people vote is with their feet. And they are voting with their feet. As a matter of fact, the domestic migration data from the state of Minnesota, originally released by the Census Bureau, said that we lost 13,453 residents to other states in 2020 and 2021. And then there was new data that came out from the IRS that said, you know what? That 13,000 something is not the number. They said Minnesota lost 16,021 residents overall in 2020 and 2021. The states that they are flocking to the fastest are the states of Florida, Wisconsin, Texas, Arizona, North Carolina, South Dakota, Tennessee, and others. And if you listen to that list, Mr. President, members, that's a list of states largely that have less mandates, less taxes, more freedom, and more personal choice for people than the state of Minnesota has. People are voting with their feet, and they're leaving our state. This bill that places all kinds of mandates on hardworking people that simply want to work and raise their family is chasing them out of our state. And here's another example. It's just a travesty. I do have some questions on how the bill operates too, Mr. President. And I was looking, I'm reading page, I think the operative pages are page 26 and page 15 and 16 of the bill. So if you go to page 26, eligibility requirements, payments that affect benefits, eligibility conditions, it says that a worker has to, or an applicant has to demonstrate that they're unable to perform regular work due to a serious health condition, a qualifying exigency, safety leave, family care, bonding, or medical care related to pregnancy. Those are the conditions for which people can apply to take the benefits that they pay for in this program. And they pay for the benefits, Mr. President, and they pay for 400 government employees here in the state of Minnesota. And they pay for all kinds of regulation, taxes, and other things that they're paying for. There's taxes on top of the pile of taxes that accumulate here in this account for the program as well. So it's amazing what we see in this bill. But page 15, family member, it says a family member means a spouse or domestic partner. I'm wondering if Senator McQuaid would yield for a question, Mr. President.
Senator McQuaid, will you yield? She will yield. Senator Jaskowski.
Thank you, Mr. President. Thank you, Senator McQuaid. So on line 15.28 says a spouse or domestic partner. And spouse, I think, you know, I'm thinking about these qualifications, and I'm going to go on to page 16 and have some additional questions as well. But I'm just wondering how people will prove that they meet these criteria. Now, spouse, of course, you probably got a marriage certificate or something that shows you're married. Domestic partner, it could be someone of the same or opposite sex. I suspect that, you live with, or I don't know how long that would have to be. Senator McQuaid, can you tell us how a domestic partner would demonstrate to the government that they're entitled to these benefits under the bill?
Senator McQuaid.
Thank you, Mr. President. So when a person has a serious qualifying health emergency or health condition, the provider would certify that condition, and then the person who is their domestic partner would submit an application for leave. They would be paired in the system, and then they would begin receiving partial wage replacement.
Senator Jaskowski.
Thank you, Mr. President. Thank you, Senator McQuaid. So if she would continue to yield, Mr. President.
She will yield. Senator Jaskowski.
Thank you, Mr. President. So Senator McQuaid, so someone would fill out the form and say, I'm person X's domestic partner. Does the government then just take that, take that for face value, or is there anything, do you have to prove that you're that person's domestic partner, or does it just happen? Does the government just take, in all of these cases, do they just take what the applicants give them?
Senator McQuaid.
Thank you, Mr. President. So the way that the system will work is that if somebody is taking leave for somebody else, to care for somebody else, they apply for those benefits. The person who they're going to be caring for gets a note from a medical doctor, and those are paired up. So you would probably have a drop-down menu that would say what your relationship to that person is. Obviously, the person who submitted the doctor's note has said you are the person who will be caring for them. Otherwise, they wouldn't give you their permission to take leave to care for them. And that is how we will know.
Senator Jaskowski.
Thank you, Mr. President. Thank you, Senator McQuaid. I still don't see where there's really a solid requirement for the person applying for benefits to demonstrate that they are what they say they are. If we go on to page, also under family member, a parent or legal guardian of the applicant, I would think that could be clearly demonstrated. Now my question is whether the government is going to even ask for that information, or from what I heard, it just sounds like the government is going to believe the application, and if it's on the application, that's the person that fits under the law, and therefore they're going to grant the benefit, as far as I hear. A sibling, on page 16 of the bill, Mr. President, a sibling, a sibling could have a different last name, and I don't know if a worker in government would know or have a way of determining whether that person really was the sibling of the person who is the worker in this case or not, or whether we contemplate in the bill, or whether we care if that person definitely is a sibling or not, because I don't see anything in the bill that shows that the person has to prove to the government that they're the sibling. Or a grandchild, the next item on 16.2, same thing. A grandparent or a spouse's grandparent. Okay, so if I'm the government and I get an application that says, that person X asks for paid family leave, and it says person Y is the spouse's grandmother, how is the government going to verify that indeed that person is a spouse's grandmother? I'm wondering if Senator McQuaid would yield again, Mr. President.
Senator McQuaid will yield. Senator Jaskowski.
Thank you, Mr. President. Senator McQuaid, same question, kind of different, grandparent, insert grandparent here. help walk through that again and provide some more granularity. How in each of these situations is the government going to know that the person is who they say they are? So how is, I mean, it sounds like from what you're talking about, there's two different pieces of paper. There's the job applicant, or the worker who is applying for the benefit, and then in this case there is the spouse's grandparent, who could be, you know, would obviously be much older than the worker, and maybe of a different last name that the government wouldn't be able to really know if that person truly is the spouse's grandparent of the worker or not. How is the government going to know that the law is being followed?
Senator May Quaid.
Thank you, Mr. President. To the good senator from Mazeppa, I think he's missing the common sense on how this is followed. When people take leave to care for somebody who is sick, dying, they are getting partial wage replacement. You have to have a doctor's note for the serious health condition that qualifies that person to take leave for you. You don't have to prove your relationship. We don't ask strangers to take care of us unless that stranger is the only person to do so. People in Minnesota get their 12 weeks of leave for themselves if they're seriously ill, or leave for a family member if they're seriously ill. They don't get 12 weeks per person on this list. So if they decided to use their 12 weeks to take care of, you know, my wife's grandmother, then so be it. These have to be paired in a system that goes with a doctor's note and a person who is saying, yes, I will take a pay cut for a set amount of weeks to care for this person. And so I think what the good senator from Mazeppa is missing is common sense, and not a list of documentation that is articulated in the bill. The process to pair two people will be put together in the system that is built, but the point is that we have a caregiving crisis, and that we want people to care for people that are close to them for whatever that relationship might be, because that helps alleviate the burden on the system, something I specifically heard from our county, which is struggling with this. Thank you, Mr. President.
Senator Jaskowski.
Thank you, Mr. President. Well, it was kind of as I suspected. Senator May Quaid, I don't think I'm missing common sense. I think this bill is missing common sense. But it sounds like there is no need for the applicant to prove that they're following the law, Mr. President. As a matter of fact, if indeed it doesn't matter and the government isn't going to look to see if the law is being followed or not, that's what I heard from Senator May Quaid, who's the author of the bill, then why do we have any criteria in here? Why do we say spouse or domestic partner, child, including all the different types of child examples that are included here? Why do we say parent or legal guardian? Why do we say a sibling? Or why do we say a grandchild? Or why do we say a grandparent or spouse's grandparent? Or why do we say a son-in-law or a daughter-in-law? These are itemized in the bill. They're enumerated on page 16 of the bill, Mr. President. And what we are hearing is it really doesn't matter. What matters is that there's a doctor's note from someone that is in the hand of the employee that they're taking to then the government to show them that they're entitled to this benefit. But what I heard, Mr. President, is the government is not going to even check to see if this part of the law is being followed. And to exacerbate this reality, Mr. President, we only need to go to item number 8 on the top of page 16. Another, according to this bill, which is about to become law, I expect, is that another example of a family member that can qualify for family care under this bill, that can qualify for family care leave, because that's what it's doing, and this one is shocking. I mean, the people of Minnesota should be shocked. It says an individual who has a relationship with the applicant that creates an expectation and reliance that the applicant care for the individual, whether or not the applicant and the individual reside together. So if someone offered some element of help, assistance, aid, whatever you call it, to another person on one day, it appears to me that the next day they could say that if that individual is in need of medical care, that they qualify for leave under this bill. So what I'm Senator McQuaid, I'm not going to ask you to yield because you've already answered the question on this, I think, and it sounds like the government's not going to check in to see that the law is followed. And if that's the case, why do we even say what a family member, why do we even say family care? Why don't we just say care for anyone you want to care for who has a doctor's slip? Because that's what I heard attested to by the author of the bill, Mr. President, and it seems that the requirements to exercise this benefit are very, very loosey-goosey, and the government is going to be a willing loosey-goosey accomplice in this whole new big government scheme called paid family and medical leave, which is a $3 billion per biennium tax on the hardworking people of Minnesota that they may or may not want or need to participate in. So on page 28 of the bill, and I don't know, maybe it's going to be similar here. It just won't matter. The government will let any applicant use this leave as long as they fill out an application, Mr. President, because that's what it sounded in the last example. But subdivision 4 there in this particular new chapter of law, chapter 268B.06, which is contemplated in the bill to become law, subdivision 4 will say not eligible. Now it's going to say that we are, so the authors are saying that these people are not eligible. An applicant is ineligible for family or medical leave benefits for any portion of a typical work week, and it includes these 3 items. Any portion of a typical work week that occurs before the effective date of a benefit account, that the applicant fails or refuses to provide information on an issue of ineligibility required under 268B.07 subdivision 2, or for which the applicant worked for pay. Now, I recall, Mr. President, and going back to common sense requires us to bear on our experiences in life and apply them to situations that we are seeing and attempting to navigate in front of us. And I remember when the state of Minnesota was adding to their paid family leave benefit, they were adding paternity leave for the fathers. And so this was an addition to the contracts. It was a new thing. And many people were wondering again, what type of eligibility verification was in place with the employer, in this case it's state government, what type of employer eligibility verification was going to happen for these people that were saying, and I'm trying to remember, I think it was 4 weeks of paid leave for the father of the baby. And as soon as that passed and was adopted, I heard from people in my district that were sharing examples of people who were government workers, and there was one very clear one that came up. And this guy was taking paid family leave for his baby, but what he was doing during the day is he was building a building for another company. And he worked for the government. So not only was he being paid family leave, but he was also getting pay from a different company because he was a government employee. And members, this is the common sense that I am talking about. There are many, many millions of people in our state that are self-directed, that all they want to do is work. And if you tell them that they don't have to work for a particular type of time, many of them will work anyway. And that's what this particular guy did, is he worked. And then he collected the benefit on top of it. So apparently, at least that particular guy didn't need the benefit, but the rules and the administration of this new law are so loosey-goosey, Mr. President, that I can't see this fund. I mean, as Senator Pratt said, I think the first person to debate earlier on this bill, at 0.7% tax on employees and employers on their income, that's not going to last very long. The limits in the bill are 1.2%. It might take 3 or 4 minutes of the program operating before that's succeeded, or before the next amendment to this comes in the form of a bill to raise it even further, because it's so loosey-goosey. Looking at page 37 of the bill, I saw some language in here that just, I don't know. I'm wondering if Senator Mayquade would yield again, Mr. President.
Senator Mayquade will yield. Senator Jaskowski.
Okay. Thank you, Mr. President. Thank you, Senator Mayquade. So, Senator, on page 37 of the bill, it talks about an employee's right to reinstatement, and this is getting into a portion of the bill that Senator Rarick was talking about earlier. And anyway, I'm looking at some language here, and I wonder what it means. So, I mean, some of this has to be and will be interpreted. I'm certain there will be lawsuits around this. There will be a lot of them. On line 26 of page 37, it says, an equivalent position is one that is virtually identical. Now, virtually identical, so to the employee's former position in terms of pay, benefits, and working conditions. So, let's say in terms of pay, so is it within 50 cents an hour? Is it within $1 an hour? What is virtually identical, and what does that mean in the bill?
Excuse me, Senator Mayquade.
Thank you, Mr. President. Senator Drazkowski, the purpose of this part is to ensure that there's not retaliation or punishment or demotions for people who take paid leave. As a mom and as a working woman, I can tell you that this is something that often happens in workplaces for people who give birth. And so part of the way that we structure these very normal, common, and found throughout law job protections is to ensure that when you come back from leave, if it's not in your exact same position, so let's say I leave my job as the special projects advisor, or I take leave for my job as a special projects advisor to EMQ Corp, and then I have a baby, I take my bonding leave, I come back after 10 weeks because I didn't need all 12 because it was okay. It was okay to give birth. But the special projects advisor role was filled temporarily while I was gone, and they really like the person who is there, and they want to have that person stay in the job. And so they can, give me a job that is substantially, almost virtually similar. My pay can't be docked, my benefits can't be docked, all of the things that I enjoyed before can't be docked. And so if it's not the exact same job, it's got to pretty much be the similar same job. No retaliation, punishment, demotion for taking paid leave. And that's what the purpose of this section is for.
Senator Jaskowski.
Thank you, Mr. President. Would Senator Mayquay yield again?
Senator Mayquay, will you yield? She will yield. Senator Jaskowski.
Thank you, Mr. President. Thank you for that, Senator Mayquay. And yeah, that is exactly what I read here too. And we are in this bill, of course, having government insert themselves between the employer and employee relationship and completely re-engineer a portion of that. And what we're trying and what we see trying to happen in this bill is to have government then come in, and I think this is some of what Senator Rarick was talking about earlier, government's having to come in then and describe and define the terms of employment. In this case, the terms under which the individual that was on leave comes back and what their situation would be. So, I mean, pay is one of the things that are outlined here and called out, but working conditions. So what if, Senator Mayquay, you've got an employer and they're a manufacturer and person was working on some sort of a molding machine when they left, but the employer went through a transformation. They outsourced the molding function of their business to another company, and they expanded another part of their company when that individual came back. How is the idea of a virtually identical position going to happen, and how are we not going to see, back to the common sense of whether this is common sense or not, how are we going to see this play out between people? We're going to see arguments between the employer and the employee, whether the new type of position, maybe this person, the next best thing the employer has is an office position, or maybe it's a different type of manufacturing machine that's a completely different department because they outsourced the other one. What's going to happen in that situation when it needs to be virtually identical as outlined in the bill? Thank you, Mr. President.
Senator Mayquay to the question.
Thank you, Mr. President. One of the best things about this bill and the brilliance of Senator Dr. Mann is that so much of this bill replicates things that we already have in law. So this part of the law that the good senator from Mazeppa is talking about is directly verbatim from FMLA. So employers are familiar with this provision, they are familiar with the law, they are familiar with how it works, and they don't need to acquire any new knowledge to adhere to this provision of the law. Not confusing, super easy. Thanks, Mr. President.
Senator Jaskowski.
Thank you, Mr. President. Thanks, Senator Mayquay. Well, members, I see again another example of conflict that this bill, as it now works to develop and heal over the terms of employment that it disrupted to begin with, as government came in and inserted itself between the employer and employee relationship. And I look throughout, page 38 of the bill, on top it begins, an employee is entitled to an unconditional pay increase under XYZ circumstances. And then it goes on to outline what equivalent pay includes in terms of bonus or payments, whether it's discretionary or non-discretionary, and then goes on to describe that. And then this almost sounds like items that would be in a union contract, Mr. President, and probably largely because it has to, because government is coming in and swooping up so much of the employer-employee relationship and taking it over. 38.16 of the bill, benefits under this section include all benefits provided or made available to employees, and then describes the types of benefits, life insurance, health insurance, disability, etc. And that entire page on 38 Page 39 in its entirety, again, is also defining from the government standpoint and dictating to the employer and the employee what their terms of employment will be as they bring back, they bring language forward as the employee comes back from this paid leave program. And then we go to page 40 of the bill, Mr. President.
Nothing, I'm sorry. Go ahead.
Then on page 40 of the bill, more conditions of employment on 40.16. If an employee is laid off during the course of taking a leave, it's the employer's responsibility to continue the leave, maintain group health benefit plans for the employee, restore the employee, and restore the employee's cease at the time the employee is laid off. An employer has a burden of providing that the employee would have been laid off and would not be entitled to restoration of a job under some other circumstances. We are seeing here again conditions of employment written into law between Minnesota private sector employees and employers. Now, there's one thing in this bill I don't know if I've seen before, Mr. President. We see in the bill language that creates a hypothetical. And that is on 40.26 of the bill, Mr. President. And I'm going to read it for members. Again, this is in the conditions of employment dictation from the bill to the private sector employee and employer. If a shift has been eliminated or overtime has been decreased, an employee would not be entitled to return to work that shift or the original overtime hours upon restoration. However, if a position, for example, a night shift has been filled by another employee, the employee is entitled to return to the same shift on which employee before taking leave under this chapter. So, however, if a position on, for example, a night shift, I've never read language like that, Mr. President, and I'm wondering if this is a fragment of somebody's, notes that they might have put together as they were working on this bill, because that doesn't look like something that belongs in law as we try to have this law properly interpreted and enacted, interpreted by the courts and enacted by our government to say, for example, a night shift. I really wonder where we're going there. Again, the bottom page 40, again, establishing the terms or reestablishing the terms of employment for every employer and employee in the program. And those, again, dictation of terms of employment really continue all the way through page 41 of the bill. And Mr. President, we are just seeing here what this bill is creating. It's disrupting what in nearly every situation that I've been aware between small businesses and their employees, a great relationship where they have the ability to be agile, they have the ability to work in the very best interest of the employee, and they do that, Mr. President, nearly every single time. And they don't need government to come in and dictate these terms of employment. They don't need government to come in and dictate benefits. They don't need government to come in and take money from that employee to turn it over to create 400 new government jobs that are going to do more and more and more to the employees and employers of our state. I've got some more comments on the bill, Mr. President, and look forward to talking about those as we get to third reading. Thank you, Mr. President.
Senator Draheim.
Thank you, Mr. President, and thank you, members, for the discussion. I have some questions, but I think I'd rather save the time for third reading. I'd like to correct a few things and just have some comments if I could, Mr. President. I think there's no doubt everybody in this chamber is in favor of some form of paid medical and family leave. We passed a bipartisan bill last year, a Republican bill. The difference is the proposal we had last year didn't create $1.5 billion new tax on our employers and our employees. And in fact, when this bill becomes effective in January of 2026, the tax will really be over $2.1 billion in that budget. Some of the discussion we had tonight was on seasonal workers. We talked about the hospitality industry. I'm grateful there was some exemptions for them. Our resort industry, especially up north, where some of the flooding occurred last year, have really been devastated. But there are more people that work in the seasonal resort type environment that are excluded. Having owned a marina for a number of years, we had a lot of partners we worked with that were seasonal. And I'm just going to list off a few here, Mr. President. Dock installers, seasonal, short time, a great way for young college kids to earn a few extra dollars. Bait shops, another great example. Season's very short. Landscapers, fishing guides, boat dealers. Another area that I think Senator Dornick talked to and others was the agricultural area. And in my area, there's a lot of part-time employment. My first job was walking beans. You walk down a row with a hoe and you chopped weeds. That's what you did all day long. But what a great experience for a young kid to earn some extra money, first job. But we have spring and fall that was talked about. Hay, baling hay, something I did and I know many in this chamber have done. And then you have the holiday season, Mr. President. We haven't talked about that. You have a ramp up in retail over the Christmas period, over Halloween, etc. Affects a lot of people. And because we bring up these issues, it doesn't mean we're not in favor of doing something. We think it's important, as do most Minnesotans. But we question how the bill is drafted. Questions I've had in the service area are tips included. I think we had a lot of questions on the language in the bill. We heard that the bill's been around for 11 years. But yet, in every committee, good questions were brought up, amendments were brought up, trying to fix the bill to make it workable. As you heard today, we had a lot of questions. I think we all know, or we should understand, that it's a tight job market out there. If employers want to retain employees, they're going to have to up their game. But every situation is different. And this bill is a one-size-fits-all mandate that hires over 400 new employees. It creates a large tax. It was mentioned that the bill that we had last year that had bipartisan support was a failure. 99% of people didn't sign up in one of the other states. The state that was mentioned was Virginia. And I would ask the author a question, but I know we don't have a lot of time, Mr. President. Virginia was brought up. And think about it, members. It's May. It's the middle of May of 2023. When does this bill come into effect? 2026. If we were going to compare this bill that we're debating today to what Virginia did, that was just signed into law, I think it was April 2nd of 2022, Mr. President, just barely a year ago. And we're trying to compare a bill that just got signed into law a little over a year ago to the one we're debating today. Very unfair. Very misleading, Mr. President. It was also mentioned we wouldn't have to train employees. And I had one of my cities come to me, drive all the way up, almost from Iowa, to tell me their concerns with this bill, Mr. President. They have a wastewater plant with 4 employees. They run every day of the year. They run 24 hours a day. And they were worried about this bill. And how would they train someone for a specialty type job to fill in if this law got enacted? And yes, they have people that have been on maternity leave. They have had people who get hurt outside of work. But not have to train employees is pretty naive. If you've been an employer or a manager, you know you're always training employees. And if people are going to be gone, you're going to have people fill in for those employees. And you're going to have to train them. And you hope your long-term employees come back. I think anybody that's had employees understands that. Senator Nelson brought up some good points on the soundness of the actuary studies that have been requested on this bill. Any insurance product out there, any non-government type of program would require such types of studies. We have plenty of time. It's only 2023. This bill doesn't come into effect till 2026 as drafted. We heard about the fudge rate, I'll call it, on what they're projecting, what their research. After all, Mr. President, this bill's been around for 11 years. They should know the answer. On the tax rate, we heard talk about the railroad language that was omitted or removed in conference committee and the concern with federal laws. Senator Abler brought up a section that wasn't even in law that was referenced, section 256.4764. This bill has been championed with a special interest group, not by Minnesotans. Outside special interest group has been promoting this bill, Mr. President. We had some discussion about the effects on labor unions and the collective bargaining. And just because we had that discussion does not mean that we don't support the concept. We do support the concept. We just don't feel, Mr. President, that it's drafted correctly. We also heard from the author, Mr. President, that the bill hasn't changed that much. Mr. President, we're on the 8th engrossment of this bill. Every committee that I saw this bill in had at least a dozen amendments attempted to be put on this bill. I believe if I counted correctly, it had 9 different stops. And I believe, Mr. President, in Finance, it was suggested it would go to more committees that it had not been to already, like higher education. This one-size-fits-all bill is not ready, Mr. President. It was also mentioned that 100% of wage benefits would be brought up next year. Wouldn't that be wonderful? In all my research on this topic over the last 3 years, Mr. President, I have not seen one state that offers 100% solely benefits. You know why, Mr. President? Because they can't afford it. Last thing I will really talk about is the FMLA that was mentioned, that employers are already familiar with a lot of the language in this bill. And I think it goes, the author of the bill, Mr. President, is not familiar with how many people and types of businesses this affects. There's a lot of people that have no idea what that is and are not affected by that federal program, not required to know what that does. And we talked about farmers earlier. But this will affect every aspect of anybody that employs a single person in the whole state, including our schools, our cities, our townships, our counties, our churches, and all business. So I urge everybody to support my motion to send this back to conference committee. We had a press conference during this debate, Mr. President, and it was suggested that it was the minority's fault that we're not going to finish on time this year. And I really question why we're having the debate on this bill today if we are in that big a hurry and not want to take the time to get it right when this bill doesn't have an effective date till 2026. So I urge all members to support my motion. Vote green. Thank you.
The Secretary will take the roll on the motion to reject the conference committee report. Members, please vote. Senator Morrison, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Mann votes no.
Senator Mann votes no.
Senator Putnam votes no.
Senator Putnam votes no.
Senator Rest votes no.
Senator Rest votes no.
Senator Wickland votes no.
Senator Wickland votes no.
Senator Klein votes no.
Senator Klein votes no.
Senator McEwen votes no.
Senator McEwen votes no.
Mr. President, Senator Bolden votes no.
Senator Bolden votes no.
Mr. President.
Senator Jasinski, those voting under Rule 40.7.
I just have one to report. Senator Coleman votes aye.
Senator
Coleman.
Senator Coleman votes aye. Senator Morrison, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Murphy votes no.
Senator Murphy votes no. All senators having voted who desires to vote, the secretary will close the roll. There being 32 ayes and 34 noes, the motion to reject does not prevail. We are now on the underlining amendments. Senator Draheim.
Thank you, Mr. President. I urge a red vote or a no vote, and I also ask for a roll call.
Roll call requested, roll call granted. Seeing no other discussion, the secretary will take the roll on the motion to adopt. Members, please vote. Senator Morrison, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Mann votes aye.
Senator Mann votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Wickland votes aye.
Senator Wickland votes aye.
Senator Klein votes aye.
Senator Klein votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
Senator Bolden votes aye.
Senator Bolden votes aye.
And thank you, Mr. President. Senator Murphy votes aye.
Senator Murphy votes aye. Senator Jasinski, for those voting under Rule 40.7.
Thank you, Mr. President. Senator Coleman votes no.
Senator Coleman votes no. All senators having voted who desires to vote, the secretary will close the roll. There being 34 ayes and 32 noes, the motion to adopt the committee report prevails. Members, the secretary will the secretary will give the bill its third reading.
House File Number 2, a bill for an act relating to employment, creating a family and medical benefit insurance program.
Third reading. Senator Pratt.
Thank you, Mr. President. Members, I urge you to reject the conference committee report today. Despite the number of sessions this bill's been around, it's not ready to be passed. Despite the number of committee hearings this bill has gone through, it isn't ready. Few real changes were accepted throughout the entire committee process. And the few Senate amendments that were adopted were either watered down or stripped out. And one in particular Senator Kroon touched on was an employer that had information a benefit wasn't a legitimate claim. There has not been an actuarial study, so we really don't know what it's going to cost. We don't know what it's going to cost employers. We don't know what it's going to cost employees. Members, I handed out a sheet based on the bill. And in every case, in the first year, except for the best case, the tax rate will go up and we will spend more in benefits and administrative costs to run the program than we'll collect in premium. Members, it is most likely the assumptions in this bill are wrong and the people of Minnesota are being misled. It's been said that this will cost the average worker $4, a cup of coffee a week. Members, not everybody can afford a $4 cup of coffee. People are living paycheck to paycheck. And how arrogant to say you can afford a $4 cup of coffee. The Democrats have benefits that are taxable. Think about it, members. Just like Social Security that we've been talking about. If you collect on these benefits, the state is going to get its cut. You're getting 60% of your normal wage, and you're going to be taxed. And if you have any question about that, members, it's on page 54. If you listen to the Democrats, it sounds like Republicans only care about business, and that's not true. Republicans care about the employees, and that's why we offered an alternative plan, a thoughtful alternative. We offered an alternative that provided benefits to employees without job-killing mandates. We offered a plan that could be implemented more quickly than this one. We offered small business a tax credit to incent participation. We allowed employees to keep their benefits if they want if they like their benefits. And we backed, and it was backed by a private insurance company rather than the taxpayers of Minnesota. And members, let's remember who these small business owners are. They're not the rich people living in mansions in one of our more affluent communities. They're our neighbors. You know, during COVID, I talked to one small business owner who very nearly lost his house because he was forced to be shut down and he had to take a second mortgage on his house to keep his business going. He was almost in tears. He plowed everything he had and more into this business. Everything he had and more into the people that worked for him. And he very nearly lost it. So when we flippantly say we don't care about employees, we only care about business, that's not true. Because we care about our neighbors. We care about our neighbors that own their own business on Main Street, and we care about our neighbors who work for those businesses on Main Street. Mr. President, despite how long this bill has been around, this has not been a bipartisan effort. Despite how long this bill has been around, it's not ready to be passed. Last time I read letters from all over the state, from people saying that they were either going to close their business, move their business, and those employees would lose their jobs. If we really care about employees, if we really care about our neighbors, members, we will vote no on final passage of this conference committee report. Thank you.
Senator McQuaid for the final comments before we vote.
Thank you, Mr. President. I want to first just take a second to honor the work that has gone into this bill. Senator Mann has taken so many amendments. Yes, they were used against us today. We took partial wage replacement, carving out seasonal workers, not exceeding total wages with top-offs. This has been an incredibly collaborative process. It's how the democratic process should work. Let's talk about Minnesotans. Let's talk about employees. They're going to be able to care for themselves, care for their loved ones without losing their homes, without not being able to pay their rent. This bill is for every Minnesotan. It is sustainable. It works in the 11 other states that have it, and it is sound, good policy. I'm so honored to be carrying this across the finish line today for Senator Mann and for all Minnesotans. I urge a green vote, members. This is a good bill, and it's going to be great for Minnesota. Thank you.
The Secretary will take the roll on final passage of House File 2. For those voting under Rule 40.7, Senator Morrison.
Thank you, Mr. President. Senator Mann votes aye.
Senator Mann votes aye.
Senator Putnam votes aye.
Senator Putnam votes aye.
Senator Rest votes aye.
Senator Rest votes aye.
Senator Wickland votes aye.
Senator Wickland votes aye.
Senator Klein votes aye.
Senator Klein votes aye.
Senator McEwen votes aye.
Senator McEwen votes aye.
Senator Bolden votes aye.
Senator Bolden votes aye.
And thank you, Mr. President. Senator Murphy votes aye.
Senator Murphy votes aye. Senator Jasinski, those voting under Rule 40.7. When you're ready, sir.
Mr. President.
Senator Jasinski, for those voting under Rule 40.7.
Senator Coleman votes no.
Senator Coleman votes no. All senators having voted?
No, Mr. President, we're still waiting on one. Sorry.
Okay.
Mr. President.
Senator Jasinski, for those voting under Rule 40.7.
Senator Rasmussen votes no.
Senator Rasmussen votes no. All senators having voted who desires to vote, the Secretary will close the roll. There being 34 ayes and 32 noes, the bill is passed and its title agreed to. Senator Disick.
Thank you, Mr. President. In a moment here, I'll make a motion to recess for about an hour. DFL will caucus upstairs in our caucus room.
Senator Johnson.
Thank you, Mr. President. And Senate Republicans will be caucusing as well, 323.
On that motion, seeing no discussion, all in favor say aye.
Aye.
All those opposed say no. The motion prevails and the Senate is now in recess until the call of the President.